be on the record. All right. We'll go on the record in the matter of Arnold and Asmussen versus Kotek, Rosenblum, and Cotting. Harney County case 22 CV 41008. Tony Aiello represents the plaintiffs. We have Mr. Marshall and Mr. Wilson sitting at council table for the defendants. It's the defendant's case in chief, so I'll turn to you, Mr. Marshall.
Good morning, Your Honor.
Good morning.
This morning, the defendants filed a motion for judicial notice. Yesterday, or I suppose last court day on Friday, expert witnesses were asked about two matters of government data, one relating to the CDC and the second related to the census data regarding Oregon's population.
Right.
In order to complete the court's record and have certainty on those issues, the defendants move for judicial notice of the CDC's current position, former position, and former position on the number of defensive gun uses per year, and as well as the U.S. Census Bureau population figures for the last 3 decennial censuses. These are facts capable of recognition simply through going to a government website, and are superior evidence to experts' memories, as expert as they are, of what the facts were as they are asked on the stand on matters they were not necessarily prepared specifically to testify on.
Understood. Mr. Aiello?
Your Honor, plaintiffs have no objection to the census data. I am a little lost on what defendants are seeking judicial notice for regarding the CDC. I'm looking here at the motion, and the motion appears to conflict with, or at least in my mind, conflicts with what Mr. Marshall just said. I don't know whether defendants are asking that the court adopt the 60,000 to 2.5 million number or not adopt it.
No, they're asking that the court find that the CDC has abandoned the studies on the range of defensive gun use from 60,000 to 2.5 million per year.
Okay. So, Your Honor, to that, plaintiffs have a couple notes here for the court. First of all, that number, the 60,000 to 2.5 million number, was relied on in Duncan v. Bonta, deciding California's large capacity magazine ban. That decision came out on Friday. And also that the CDC has drawn scrutiny for abandoning that number and has not explained the reason for abandoning that number. I can provide this as an exhibit to the court, but there's been several letters sent to the CDC by United States senators. This one is particularly interesting. This is from Senator Chuck Grassley, who notes, according to the release emails, Mark Bryant of Gun Violence Archive lobbied against the study references on the CDC website. He stated, quote, that 2.5 million number needs to be killed, buried, dug up, killed again, and buried again. And so this does seem to be a little bit of political posturing regarding the 2.5 number. I note that the number was reached by the CDC during the Barack Obama administration in 2013, and then it was abandoned during the President Biden administration. I believe it was abandoned in 2021. Those numbers are still, as demonstrated in the Duncan v. Bonta decision, still capable of being located. I do believe I have a copy of the study, but you know, the CDC's abandonment of that number, I would say says a lot more about politics and a lot less about defensive uses of firearms.
Go ahead.
The plaintiffs introduced the CDC figure. So to the extent the CDC's view of this is not relevant, then and an objection was sustained as to the fact of the CDC's reliability or something of that nature, it seems that that would support a motion to strike the testimony on that point. We are not introducing this evidence to demonstrate definitively these are the true answers. We are simply saying the CDC has to complete the record on the CDC, including the fact that what was testified to on the stand was the 2.5 number, the top end of the range. But the actual estimate that was being relied on was actually the full range between 60,000 and 2.5 million.
Mr. Ayala definitely said that range.
I understand, and I'm not.
I think this, what I would allow this in on is impeachment evidence against the plaintiff's case, that those numbers have been abandoned by the CDC. It sort of undermines the questioning that he made with regards to those numbers. And to that extent, I'll admit it through judicial notice. And I'll admit the remainder through judicial notice as well.
Thank you, Your Honor. The second matter is, and perhaps the court wishes to take this up at another time, but the court reserved ruling on the admissibility of Exhibit 105. So we need to handle that at some point before, well, ideally before the close of evidence.
Sure.
Mr. Jendal and Mr. Aiello discussed that exhibit, and so we're prepared to, well, I think the record's been made on it, and so just need to have a ruling at some point.
Anything else about 105? That's the police reports regarding Las Vegas.
Yes, Your Honor. Plaintiffs would note, again, just as far as relevancy is concerned, this tragedy occurred in Las Vegas, Nevada. No law in Oregon will prevent a tragedy in Las Vegas, Nevada. There's been no showing by defendants of such similar tragedy in the state of Oregon, and plaintiffs continue not only their hearsay objection, which I understand the court was considering, but also their relevancy objection. And as far as the hearsay objection goes, Your Honor, plaintiffs would note that while this report does describe the activities of the office or agency, that's not the purpose for which it's being offered. The purpose for which it's being offered is to show that so-defined large capacity magazines were utilized in the shooting. Additionally, plaintiffs note that the sentiment has been, well, the shooter used 100-round magazines. Plaintiffs will also note, just for the record, that Ballot Measure 114 does not only ban 100-round magazines, it bans all the way down to 10-round magazines. And so the probative value of looking at an extreme case where 100-round magazines were used, plaintiffs would assert is not probative of the number in question in this case, which is 10.
Is there anything else?
I think Mr. Ayala was referring only to the exception of 803-8A for activities of the office or agency. This is also qualifies under the hearsay exception for 803-8B, matters observed pursuant to a duty imposed by law, as to which there was a duty to report. This is the report of the Las Vegas Police Department.
I would overrule on hearsay. As to relevance, it is one of 179 mass shootings. It's already accounted for in the overall findings of the court, or will be accounted for as one of those 179, and accounts for a number of the casualties, fatalities, and overall casualties that are associated with the 1,000+ and 1,000+ numbers that were presented previously to the court through the defendant's evidence. I find it cumulative and not relevant standing alone, so I'm going to exclude it.
Your Honor,
I don't doubt that these mass shootings are horrific. I've never suggested otherwise.
Your Honor, the next matter for the court is defendant's motion for leave to file offers of proof. We filed that on Friday, presented both plaintiff's counsel in the court copies. The argument is set forth in the brief accompanying that motion, and we would rest on that argument.
Your Honor, plaintiffs agree with Your Honor's prior ruling that the time to make such an offer of proof was at the motion limine hearing to give plaintiffs appropriate notice so that they could also make their own offers of proof.
Go ahead.
I don't understand the offer of proof rule to incorporate any kind of notice requirement. Our understanding is that we are permitted to make an offer of proof when we understand that evidence or testimony has been excluded. As we argued last Friday, at the time of the motion in limine hearing, the motions were addressing general concepts, not specific witnesses. When these offers of proof are presented to the court, they incorporate our specific witness testimony that would have been presented at trial. We understand that Your Honor has made a ruling with respect to that, and so we're just simply presenting this motion, but haven't, I think we've set forth what our argument is in the motion.
Well, in terms of Dr. Siegel, I've already ruled that the defendants failed to lay a proper foundation under 702. I'm not going to allow an offer of proof. I said that actually at the end of the presentation of that particular witness, and I'm not going to reconsider that determination now. As to the other three witnesses, they were not called, not sworn. I don't have any idea about their background or what type of scientific evaluation and opinion that they're rendering under 702, so I'm not going to allow it either. So the motion for offer of proof is denied, and I'll strike the filings.
Just one, may I be heard on one follow-up on that?
Mr. Wilson, I'm certainly, I feel free.
I appreciate it. Thank you, Your Honor. I did want to just point out for clarification purposes that two of the witnesses mentioned in the motion were the fact witnesses who were survivors or family members of survivors that we understood the court to exclude as part of the motion in limine hearing.
I did exclude both of them, yes. So I will say on those two individuals, I actually thank you for pointing that out. Do you have anything further with regards to, so you're talking about witness 3 and 4, or is it 2 and 3?
I believe they're 2 and 3. It's Joshua Friedland and Paul Kemp.
4 and 3 and 4.
3 and 4. My apologies, Your Honor.
Anything further? You haven't had a chance to look at those offer of proofs with regards to 3 and 4. I'd be happy to leave it open for you to review those before I make a final decision on that.
Yes, Your Honor, that'd be much appreciated. I have many unread emails that have pushed it down my list.
Only 523 pages.
Yeah. So it's a lot to read. Your Honor, plaintiffs would also note that this is still a facial challenge to the law and those witnesses.
Right, I understand that. The foundational question is whether they can make an offer of proof of these eyewitnesses as a responsive pleading to the court's original finding that it wasn't going to allow this type of testimony, because I don't think it's particularly relevant to the question of a facial challenge. I think they have a right on those types of issues to augment the record, most likely, but I'll let you respond to that. The other ones, they have to lay a foundation, which they failed to do, at least with one. And I'm not going to allow offers of proof over that failing. So But I will consider 3 and 4 and potentially admitting it over your objection, just as an offer of proof in response to the court's previous ruling. I'll give you some time to think about it.
Thank you, Your Honor.
One last issue, Your Honor. We are making it at this time an oral motion for directed verdict under ORCP 60. We'll argue that motion as part of the closing arguments and by incorporating our trial brief. And with that, that would be our last issue before we rest.
I noted the defendants filed a memorandum of law regarding the Oregon State Shooting Association and Multnomah County. I'll review that. I'll allow you time to respond to it in writing. I don't think I'll be making a final decision today. There's a massive amount of information that has been provided to this court, and I want to think through all of the arguments that have been made by both sides and make sure that I come to the right conclusion of law. And then you provided at one point the selected definition of large capacity magazines, which is in this court's record. Did you have a specific basis for this?
It was in reference to some testimony Mr. Georgiolitis provided, and I will also be addressing it during the closing argument.
Okay, so this is to sort of say that these different states have similar laws to the one being proposed here in Oregon, and you're still able to buy modifiable magazines in those states.
Yes, in part, Your Honor, we'll be making an argument under the borrowed statute rule.
Okay,
And
I don't know that rule.
I'll do my best to explain it. I wasn't familiar with it myself, Your Honor.
And Your Honor, plaintiffs do have a motion regarding those laws. Plaintiffs are going to ask to strike those laws and are prepared to argue that now if the court's prepared to hear it.
So this was offered in the case in chief. It wasn't ever offered, it was filed in the case in chief. What are you wanting me to do with this? It's not currently evidence, it's something that was filed.
Agreed, Your Honor. We provided it merely as a reference for the court so that the court could have those statutes in front of it as we discussed the statutes in our closing. It wasn't intended as a separate motion.
You can argue it then too in your rebuttal or before. So you're closed?
I'm sorry, say again, Your Honor.
Closing?
Yes, I'll address it during closing.
Okay, and you're resting at this point in time.
At this time, the defense
And
has.
you moved under ORCP 60 for a motion to dismiss the plaintiff's pleadings.
For directed verdict, yes, Your Honor.
Directed verdict. Okay. You'll have to make the motion at a different time. You haven't made it at the right moment under the rule. Go ahead, please. If you would, do you have any rebuttal evidence?
Yes, Your Honor. Plaintiffs recall Scott Springer, who is appearing remotely.
Mr. Springer, are you there, sir? I forgot my note. Oh, no, I didn't. Yes, I did. I left my notepad in there. Just I have to get another notepad. Yeah. Mr. Springer, are you able to hear me?
I am here, sir.
All right, thank you. Do you have a camera associated with the device you're calling on?
I do. Can you see that?
No. It's fine.
It has a red X on the, there we go.
There you are. Okay.
Does that work?
That did work. I am able to see you now, Mr. Springer. Mr. Springer, you're still under oath in these proceedings. Do you understand?
I do.
All right. Go ahead, please, Mr. Aiello.
Thank you, Your Honor. Mr. Springer, you observed Mr. Yurgielaitis' testimony, correct?
I was able to watch part of it. The internet here in the country wasn't so good, but I watched a large part of it.
Can you please tell the court about firearms that accept multiple magazines?
There are, over the last probably decade, a little bit longer than that, people have been trying to increase capacity, so they found different ways to do that. And one of the ways to do that is to add multiple barrels, multiple magazines. So they're available in pistols, shotguns, rifles. More prevalent in shotguns, I think, because it's a little easier to do.
How are those multiple magazines connected?
In some cases, they have an additional opening with its own its separate opening. Sometimes they are attached via like a cylinder for the shotguns. So it'd be like a big revolver, but each cylinder would hold multiple rounds, sort of similar to the stacking of the full-time technology.
How does the user of the firearm switch between magazines?
Well, in the case of the rifles and the pistols, they would remove each magazine and then insert a new magazine. In the shotguns that I'm most familiar with, they either self-rotate once one tube is finished, like on the X-Rail, it'll automatically go to the next set of tubes. I think it has 5 tubes. And then some of them you have to do manually, so you would have to rotate the magazine tube. So they're fully loaded the whole time. But you would just, once you're done, emptied one, go to the next one, shoot, go to the next one, shoot until you're done.
What are the capacities of the shotgun you were just speaking about with, I believe you said 3 tube magazines that you manually rotate? What are the capacities of each individual magazine?
I believe they're between 5 and 7 rounds, depending on the model. There are several manufacturers that make them, and then there's manufacturers that make them that have dual barrels and dual magazines that I don't really know how to describe other than that, is that there's 2 sets of barrels and 2 sets of magazines.
So would it be correct to say that the individual magazines fall below 10 rounds?
Correct.
And would it be correct to say
except for the
that
X-Rail? With the X-Rail, it can hold more. So with these subjects, there may always be an exception, and there may be one that I'm not aware of. I mean, there's so much stuff out of there. I'm very aware of a lot of things, a good deal amount, but there may be a rare exception.
are there some that accept greater than 10 rounds in each individual magazine?
There may be, I think, with the X-Rail, depending on the length of the shell you're using.
Do some of the firearms allow the user of the firearm to switch between magazines without pausing to manually change which magazine is feeding into the firing chamber?
Correct. Yes.
Can you tell the court an example of one such firearm?
The X-Rail, and that can actually be fit to a standard shotgun. It isn't manufactured as that shotgun, so it can automatically, change magazines.
What's an example of a pistol that allows the use of multiple magazines?
There is one example, and I there's so much on my mind right now. I can't remember the model off the top of my head, but it is actually a 1911. Which, can I show examples so that I don't have to wave my hands this time, or is that okay?
Your Honor, is it okay if the witness shows a firearm?
Any objection?
No objection.
Go ahead.
You can go
Okay,
ahead,
so
Mr. Springer.
This is a 1911. So the model that fires this actually has, the frame is twice as wide. It has 2 openings. It has 2 barrels and a trigger. So in each shot, it'll fire 2 shots and it'll take rounds from each magazine.
And for those, what is the capacity of each individual magazine?
Between 7 and a lot more than that. They have custom magazines that get really big.
So for the 7-round models, the total amount of rounds utilized in the firearm would be 14?
Would be 14.
Plus 1 in the chamber?
2, because it has 2 chambers.
So 16 rounds total, right?
Correct.
Are there also rifles that utilize multiple magazines?
There's a few variations in the AR-15 style that utilize a similar configuration as I just showed you. They also stack them. Is it okay if I show firearms again?
Yes, Mr. Springer.
I mean, I just want to make sure everybody's clear. This is an oral record, so, but okay, go ahead.
Understood,
just
Your
for
Honor,
clarity,
just a demonstrative.
if you have any questions. So that they would be stacked in this orientation versus this orientation. So they would be stacked vertically versus horizontally. And then there's also many configurations of Gatling gun type where they will take 2 of them together and feed them via either magazines or belts. So there would be multiple magazines or belts. The Ruger 1022 is a common gun that people use to make those.
I'd now like to talk about power factor and the interplay with capacity for different firearm users. Do you recall the testimony regarding the preference for, I believe this was Professor Tvetskov's testimony about the pepper box being preferred over the Colt because of the capacity? Do you recall that testimony?
Yes, and I recalled even that it was preferred, even though it was less reliable, that the consumers were making the choice for the pepper box because of the capacity versus the power.
Is the same true today?
Absolutely. The most popular selling guns, for as long as I've been doing this, have been the smaller pocket-sized guns. Now we have a class that's a little bit bigger than that, which is illustrated by the P365, the Springfield Armory Hellcat. So it falls between the pocket-sized pistols and the service pistols, and they've been able to increase the capacity, and they by far have been the most popular moving pistols for people that are buying guns for self-defense, and just in general, they've been by far the biggest sellers. I think by far, it's not even close.
Do you recall Mr. Jurgielitis' testimony regarding his 10 millimeter 1911?
Delta Elite is the particular model made by Colt, correct.
Those 10 millimeter rounds, can you describe for the court how they compare with regard to power factor to a 9 millimeter round of ammunition?
They are double, twice as much. So a typical a typical 9mm is anywhere between 115 to 124 grain bullets, moving about 1,250 feet per second. A 10mm with a 230 grain bullet can go the same velocity, but double the bullet weight. It was developed for the FBI. The FBI abandoned that platform. They came out with the 10mm light or the 10mm FBI, which then became the 40 caliber. They abandoned it because their agents couldn't handle the recoil and it was damaging the guns, even with what we call a shock buff, which reduces the impact of the slide on the frame. And you actually have to, in those 1911 10mm, you have to use a double recoil system, spring system, so that the gun is able to be used at all.
Do you know anyone who is related to the creation of that round?
I do. My barrel maker for the last 20 years is Irving Stone III, and his father was junior and his grandfather was senior, and his father and grandfather helped develop that round for Norma out of Sweden. They had developed it for the Bren 10. They took a 30 caliber Remington and they cut it down. They wanted a round that was between the 9mm and the 45. So the case head is nearly exactly between those two rounds.
Do you
I'll strike exactly.
think
It's nearly between those rounds.
Do you think that is a good firearm for home defense?
I don't like to comment on people's choices for self-defense because everything's a little bit, everybody's situation is different. I would say that when I heard that he is using the Colt Delta Elite, which is, I would call a rare firearm to be purchased these days, I went to Colt's website. I thought they had stopped producing them in, 96, but they reintroduced them, I think, in 2006, and then redesigned it and reintroduced again in 2016. But their website says that it's suitable for hunting medium-sized game, which would be white-tailed deer, bears. You could go all the way up to, if you were in bow hunting distances, you could go up to elk and moose. And then they also say that it is, I may butcher this. You can go to their website and find out exactly for sure, but it's special security operations, which I would assume would be like the elite of the elite military type applications, but they do not list it for self-defense. They do list the 45 version and the 9mm versions for self-defense.
Your Honor, we move to strike the testimony of what the Colt's website says is hearsay.
He's an expert witness and he can rely on hearsay.
I don't believe a foundation has been laid for Mr. Springer to rely on the websites. Mr. Springer was qualified as an expert as a gunsmith, not as an expert in the commercial sale of firearms.
He's a gunsmith and he understands the technical aspects of the firearm, and he's testifying regarding the technical aspects of the firearm, including what the manufacturer recommends regarding the firearm.
That doesn't mean that he would have an expertise in the truth or lack of truth of what's reported on a website. I absolutely agree that Mr. Springer has an expertise in the technical aspects of the firearm, but what a website says is not the technical aspects of the firearm.
Plaintiffs will also note, Your Honor, that Mr. Springer is an FFL, and we can lay the foundation for commercial sales if necessary. Plaintiffs do not believe it's necessary, but he's an FFL and is actively engaged in the commercial sales of firearms through his business, Springer Precision. So the foundation can be laid if required by the court.
Well, I'm going to sustain the objection without proper foundation. It's a hearsay. So that's what I would say.
Actually,
He was offered as a gunsmith. I knew he had an FFL, but he was offered in a different capacity to the court, and had no foundation for the remainder has been made.
understood, Your Honor. Mr. Springer, regarding that round of ammunition, is one of the concerns that the round could go through walls more easily because of its power factor?
That's a very big concern with that round, is that it is high velocity, high bullet weight. So rounds that might be deflected by sheetrock, 2x4s, and other obstacles that you would find regularly in homes, that will actually just go straight through it versus possibly being deflected with a lower velocity round or a lower weight round.
I believe you testified that the 10 millimeter was replaced by the 40 caliber. Is that right?
It was immediately replaced by the 10 millimeter FBI and then the 10 millimeter light, LITE, which was in a direct result of the battering issues that the gun had, which is, just the violence of the slide moving and the inability of the FBI agents to do follow-up shots. Also, the grip size had an issue to do with it. So that's why they downloaded it. When they downloaded enough to meet those parameters, they realized that they had excessive volume in the case. So they shortened it and created the now 40 caliber, which is common in law enforcement. And the FBI adopted that due to that reason. So it was a very short-lived round for the FBI.
Can you please describe for the court how power factor and capacity interrelate regarding a firearm for home protection versus a concealed handgun?
Could you repeat that? I sort of got lost there.
Okay. Can you describe for the court the interplay between power factor and capacity when choosing a firearm for home protection versus a concealed handgun?
Okay, I think I understand that question. So what I would say is when you think of power factor, that's the amount of power being transferred to the shooter. So that's a calculation of recoil. So in a home situation, it may vary. If you're a single person and you're the only person in your home and you also concealed carry, you might be able to use the same caliber for everything. If you have a home full of people that vary in size, experience, age, you might want something that everybody can use versus just one user in the home. So depending on your home situation, it could vary a lot. You might, have some 22s, you might have some 45s, you might have a shotgun. A shotgun, like a 12 gauge, is not very suitable for, say a young teen-aged person or a small woman. They may not be able to handle that. It also has disadvantages in length if you have a small room. So having for home defense, you're looking at a different scope of user than I would say concealed carry in public, where you're looking at the individual user who's carrying it.
How does the strength and skill of the firearm user affect which firearm is best suited for that user?
Well, typically when we're shooting firearms, we're creating an explosion right in front of our face. And as humans, that's not a natural experience. So if you're shooting a firearm that has more power than you are comfortable using, the basic skills go right out the window, to put it bluntly. If you shoot a gun that is a firearm that's more appropriate for your comfort level, you can still maintain your accuracy. And in shooting any target, if you don't hit the target, there's no value to that shot. You might be actually more dangerous if you can't hit the shot. So it's critically important that whoever's firing a firearm is able to hit the target that they're engaging. So if they're overpowered in the caliber, that is really detrimental to hitting the target.
Are higher are higher power factor firearms recommended for newer firearm users?
Objection, Your Honor. I'm no longer clear what this.
Hold on.
I'm no longer clear what this testimony is rebutting. We haven't presented any. Our case didn't concern power factors or the caliber of weapons. We didn't make any present any evidence on this, so I would object that it's outside the scope of the case we presented.
Your Honor, Mr. Yurgielitis made some pretty sweeping recommendations about what it is that civilians need as compared to law enforcement. And specifically, he testified that that civilians do not need more than the 9 rounds that he uses himself. And he made reference to the lieutenant in the back and said, he needs more rounds than I need now as a civilian. And Mr. Springer's testimony is going towards the interplay between power factor and capacity, and is specifically rebutting that testimony, speaking about the way the firearm operates, the recoil, and that interplay between power factor and capacity to specifically rebut Mr. Yurgielitis' testimony.
I understand Mr. Yurgielitis testified about his personal choice for firearm for self-defense. Mr. Yurgielitis also testified about the different responsibilities between civilians and law enforcement. But that testimony did not concern, at least as I remember it sitting here today, power factor or caliber. It concerned what his responsibilities were as a civilian and how they differed from his responsibilities when he was a law enforcement officer. I also understand that some of this testimony was presented in plaintiff's case in chief, and it, at this point, seems cumulative.
I believe that, well, the way I understood Mr. Yurgielitis' testimony was he was saying for self-defense, you only need a certain number of rounds. He indicated for himself he needed 9 rounds of a certain caliber. I'm going to overrule the objection. I am going to say that there's a point at which it becomes cumulative, and really we need to.
Understood, Your Honor. And we're
I'll overrule the objection.
We're almost done with this section, Your Honor. And then Mr. Springer, I'm sorry, I don't think I got. Did you fully answer my question, Mr. Springer?
I believe I did to the best that I understood it.
Okay. And then also, how does power factor factor into choosing a firearm when the expected use of the firearm at home is going to be in urban versus rural environment? Maybe we'll say, let's compare someone in an apartment complex versus someone with land and neighbors not so nearby.
One of the most important things when it comes to shooting any firearm at any time is safety. So one of the premier rules is know your backstop and what's behind it. In an urban environment, say an apartment, you have neighbors above and possibly below, beside. You're surrounded by people that are, literally pieces of sheetrock and 2x4s away. So the amount of power that you want to use in that situation would greatly vary than, say, in the country where the threats might be totally different. You have long ranges. In an apartment, you might have 7 yards. Out in the country, you might have 70 to 700 yards, depending on what the situation was. So you would use a totally different set of criteria to make that determination.
And so in an apartment type situation, where I believe you're saying a lower power factor is recommended, can a user make up for the lower power factor by increasing capacity?
I don't know that makeup is the correct term, but it may be a more appropriate choice. And if you're using a less powerful anything and you want to make up the gap between something that's more powerful, you can do that in volume. And so capacity absolutely would make up in volume versus, the power.
Mr. Yurgielitis testified regarding the availability of firearms that come standard with magazines of 10 or fewer rounds. Do you recall that?
I do.
Okay. Those are generally available for the subcompact and compact varieties, right?
Objection, Your Honor. First of all, there's been no foundation laid for the witness to know the commercial availability of firearms. Second, Mr. Aiello's own witnesses, including Mr. Callaway, have testified about the commercial availability of firearms with various magazine capacities. We heard quite lengthy testimony that broke down the various sizes of the firearms, the kinds of magazines that came with each of those sizes. And I don't understand how entering additional cumulative testimony at this point makes any fact more or less probative.
It's just a foundational question, Your Honor. I'm getting somewhere different than I believe Mr. Wilson expects I'm going.
Well, maybe you should go there because
Okay.
I already have that evidence on the record. It is cumulative. Go ahead.
Understood, Your Honor. Mr. Springer, do subcompact and compact firearms have more muzzle movement?
Typically they do.
Why is that?
Because you have less leverage to counteract the recoil. With a shorter grip, you don't have anything to offset the bullet coming out of the end of the muzzle. So with a longer grip, which can be achieved several ways, you can counteract that by putting leverage towards the bottom of the grip. So the longer the grip, it would be the same as prying up a rock with a 1 foot pry bar versus a 3 foot pry bar. It's just merely a matter of leverage. When you take your support hand, you lock your wrist out, you apply the pressure to the very bottom of the grip that counteracts that recoil of the firearm as the bullet leaves the barrel.
Can magazine extensions improve the leverage you just described?
They absolutely can. If you can't get your entire hand onto the grip, they can allow you to get, say, I don't know what they call this finger, but your third finger and your pinky onto that, which would add another inch of leverage to that grip. And that's very significant, especially in the percentage of the grip that you're gripping. If your grip's 3.5 inches and you add you have an extra inch to grab onto, then that's quite a bit of an advantage.
Is a firearm magazine an integral part of the firearm?
Yeah, absolutely. It's the magazine. It's where the powder is stored. So a magazine is useless on its own. A firearm without a magazine that requires a magazine is useless on its own. Only when they're combined do they produce the fire to produce the bullet leaving the barrel.
Are you familiar with the MP internal 10 round magazine?
Very. It was one of I'm not sure, Yurgielitis. He presented that as one of the magazines that could only hold 10 rounds.
Is that correct?
That model without a different part can only hold 10 rounds, and that if that caliber is inserted.
Is there an
that caliber in
extension
that
for
one
that
would be
magazine?
9mm. There are. We manufactured them. I designed one many years ago.
You heard Mr. Yurgielitis' testimony regarding tools and parts, right?
Correct.
Are tools necessary to maintain any firearm?
Correct. Yes, they are.
can you remove an epoxy base plate without a tool?
If you have heat, I don't know if
What
heat
about
would be
pressure?
considered a tool.
What
Pressure,
about
you would
pressure?
need pressure. You would need pressure. And to move anything, you need
Without
pressure.
without a tool, how can you apply pressure to a magazine to remove an epoxy base plate?
You could hold it in one hand and press it against a table.
For the firearms that utilize detachable magazines today, how would a citizen create their own magazines for those firearms?
Objection, outside the scope of our case. I don't believe we presented any testimony on this, and this appears to be an entirely new issue.
Your Honor, Mr. Yergilitis testified about kind of speculatively plaintiffs would assert about the market, and that's what this testimony is going to.
I'll sustain.
Mr. Springer, do some 40 caliber magazines accept 9mm rounds?
Yes, absolutely.
In a magazine that is made for a 40 caliber firearm, and is limited to 10 rounds, how many rounds of 9mm ammunition can you fit in that magazine?
Well, there's a huge variety of magazines, but what I will say is that, as we discussed earlier, the 10mm round, which is also the same diameter, I mean, it's a 40 just longer, basically. They designed that between the 9mm and the 45. So due to the diameter differences, if you use say a 1911 magazine that has that will only hold 10 rounds without any tools or parts or anything else, that magazine, using the math and using practical experience, will hold an additional round. So the difference is about 40 thousandths. So if you multiply that by 10, the diameter of a 9mm casing is about 381 or something like that. But so using the smaller diameter round in a 40 caliber single stack magazine, simply a straight up magazine, you will get an additional round. The same thing would go with the 45 and the 40 if they're, like in a 19 configuration where the length is the same, and you could insert it and use it in the same the slide, the barrel, the extractor, the top assembly, and you can actually replace that with a different caliber, from 22 caliber all the way up to like 45 super. So you may need something if you were not using the appropriate gun that those bullets went into, but if you're using the appropriate firearm that those bullets go into, there would be no modifications of anything.
And I think this is obvious enough, but you would put different ammunition into the magazine. In other words, in using it in 9mm, you'd have to use a 9mm round. Using it in 40 caliber, you would use a 40 caliber round.
Correct, but if you put that same 40 caliber magazine loaded with 11 rounds into the 9mm, it would function. So,
and when you say
I believe it is, if you had if you had two guns, one's 40, one's 9mm, that the capacity of that, I believe the capacity of the magazine is what is at issue. So if you put it in the appropriate caliber for the gun, it will fire. Unfortunately, we found out with a customer who actually did fire 9mm through a 40 caliber and called to complain that their accuracy was really bad and the gun wasn't very reliable. Yes, you can shoot 9mm out of a 40. It's just not very good or recommended.
Thank you. No further questions.
Go ahead, any redirect?
Yes, Your Honor. Mr. Springer, if I owned a 9mm handgun that would accept a 40 caliber magazine, I could purchase that 40 caliber magazine that is limited to 10 rounds, load it with 9mm ammunition, and put it in my 9mm firearm, right?
That is a plausible scenario.
So the magazine being limited to 10 rounds being designed for the 40 caliber would appear to only accept 10 rounds of 40 caliber, but could accept 11 of 9mm ammunition. Do I understand you correctly?
Correct. And in my previous testimony, I pointed out that the 9mm mags for the common service pistols that we discussed had ridges, and that was to reduce the space. The common service pistols are designed to, the frames are designed to use either 9mm or 40. So the only difference generally in the magazines is that there'll be an expanded volume for the 40 caliber and a reduced volume for the 9mm. So the same magazines would function in either the 9mm as far as accepting it, and then the 40. The 40, of course, would not feed into the chamber, so you can't go the other way, but you can go from 9 to 40 as far as adding capacity with no changes of parts or tools.
Why do you use power factor as your standard for assessing a round?
I use it in this specific case because we're talking about the totality of the population of Oregon and the Oregonians that would be using these firearms, and the ability to control those firearms is crucial. So that's why I chose to use firearms in this application. In other applications, I might use another term, but being able to control your firearm and make sure that the rounds are going to your target in a way that's controlled and accurate is the number one requirement for me in getting rounds to a target, which I think is the goal in self-defense.
No further questions, Your Honor.
Thank you, Mr. Springer. You may disconnect or remain on the line, but we're going to mute you at this point. Thank you.
Thank you, sir.
Mr. Aiello.
Yes, Your Honor. I have one more rebuttal witness. Plaintiff's call, Mr. Calloway.
Mr. Mr. Callaway, you can take a stand again, sir. You're still under oath. This is Benny Callaway from the case in chief for the plaintiffs. Go ahead, please.
Yes, Your Honor. Mr. Callaway, did you observe Mr. Yergielaitis' testimony?
I did, yes.
Do you recall his testimony regarding a 10 round Glock magazine?
Yes,
Do you recall his testimony that that magazine could not be altered to accept more than 10 rounds without tools or parts?
yes.
Have you modified that magazine without tools or parts?
Objection, I'm ambiguous. I'm unclear what that magazine refers to in this line of questioning.
I'd have you clarify for the record.
Yes, Your Honor. Have you modified the 10 round Glock magazine utilized by Mr. Yergielaitis without tools or parts?
Same objection. There were a lot of magazines in that testimony, and I do not know to which one he's referring.
Do we have the exhibits of it? I believe it's exhibit 174, but I'm sure Mr. Callaway can identify it for me.
It's in the box. Is this what you're talking about?
Yes, Your Honor, I believe so.
Show you what's been previously marked as Exhibit 174.
Yes, Glock 17 9mm 10 round magazine.
Have you modified the magazine or a similar magazine to, I'm sorry, I'm going to back up. Have you modified that same magazine that is contained within Exhibit 174 without tools or parts?
Not this exact magazine, one exact to the make and model and manufacturer of the magazine. I did need a tool on this particular magazine. I needed a pocket knife to get the base plate off of this one. I did not have to use any extra parts. I just removed the locking plate in the bottom and a few coils off of the spring, and then it holds 11 rounds.
Can you explain for the court how you removed the coils?
The coils, I just bent them back and forth till they broke.
After removing the additional coils, how many rounds of ammunition was the magazine able to accept?
11.
Have you accomplished the same result of 11 rounds in a 10 round magazine without tools or parts?
Yes, I did.
What firearm magazine was that for?
That was for a Glock 27. It's a 10mm magazine, 10 round double stack. With that guy, it's an ETS magazine manufactured by ETS. The pin on the bottom is a little bigger than the one on the Glock. I was able to use my tooth to push that, slide the plate off, just remove the locking plate for that, reinstall the base plate, and it now holds 11.
Did you also remove springs on that magazine?
On that magazine, I did not have to remove springs,
Did you have to remove anything?
just the locking plate.
So would that be fewer parts contained within the magazine?
Fewer parts are contained in the magazine. Magazine capacity is shortened by the length of the tube or the amount of stuff in the tube, as in the follower, the spring, the retaining plate. So if you remove some of those components, especially if they're not necessary to function of the magazine. So the 10 round Glock magazine has extra coils in there to take up some of that space. So when you break those off, the magazine will still function just fine. If you need to make sure that retaining plate stays locked on there, you can bend the tail of the spring down to fit in the hole, and it will hold the base plate on for you. Yeah.
No further questions.
Mr. Wilson?
Thank you, Your Honor. Let's start with the Exhibit 174. Do you still have that
I can get it back for him.
Not sure you'll need to look at it, but just in case.
Uh-huh.
And so when you modified this magazine, how long did it take?
Around 15, 20 minutes.
And I just want to make sure I understand the process. So you started by depressing the button at the bottom of the base plate with a pocket knife?
No, I started by cutting the Glock molds into the base plate to hold the floor plate on, base plate on. They're molded into the side. Those can be removed. They're not necessary. I've removed lots of them throughout my career. And then I use the pocket knife to depress the button on the bottom.
You said cutting, was it the locks?
Mhm.
Did I get that right?
Yeah.
Okay. And how did you do that?
With a pocket knife?
Okay, so you cut the locks, then you use the pocket knife to remove the base plate.
Yeah.
Okay. And then once the base plate was off, what steps did you take?
I determined how much extra spring was in the magazine that didn't require for it to function. And that was about 4.5 coils. And then I picked that spot and I bent it back and forth in my fingers till the spring broke, work hardened it, and put it back together, tried 11 rounds, and they went right in there.
How did you know to choose 4 to 4.5 inches of spring?
That's
I think you said coils.
I'm
Yeah,
sorry,
coils.
coils.
Yes, coils
Four,
of spring.
4 to 4.5 coils. How did you know that was the appropriate
When I
amount?
removed the base plate, spring, of course, stuck out of the bottom. And I looked at it and went, well, there's about 6 coils sticking out. I can take 4 of those off safely. And removed 4 of them, tried it, and that was all the further I needed to go.
I'm just kind of curious, like how you knew that it was safe to remove 4.5 coils. Is that based on your experiences with firearms?
Yeah. I'm sorry, yes.
Thank you, sir. With respect to, so after you broke those coils off, how did you put the spring back into the magazine?
Just slid it back in the same way it come out. And then put the floor plate back on.
Did you fire the firearm? Did you insert the magazine into a firearm and fire it after this?
I did insert it into a firearm, but I didn't fire it. I did cycle a few rounds through it to make sure it fed them into it like it should.
Did cutting the spring reduce the spring tension inside the magazine?
Yeah, it actually helped load it.
I'm sorry, say again.
It actually helped load the magazine.
And did cutting the coils, in your opinion, affect the overall reliability and long-term use of the magazine?
No.
Have you continued to use that magazine?
No, I've only tried it the once.
Are there other Glock magazines other than this specific Glock 17 9mm 10-round magazine that you could modify in the same way?
I imagine that you could modify a lot of them the same way.
You use.
I have not proven it.
Yeah. You have this
other than the Glock 27.
This is the only one you've tried it on.
The Glock 27 as well.
Right. We'll come to that one in just a second.
Sorry.
No problem. Okay, so let's talk about the Glock 27. You described this as an ETS magazine?
Yes.
What did you mean by that?
That's the manufacturer. It's an aftermarket magazine.
Mm-hmm.
Kind of helps because it's clear. You can see through it and see what's going on inside.
And so this particular aftermarket magazine is constructed in such a way that you could use a tooth to remove the base plate?
Yep.
Is that true for all aftermarket magazines?
No. But you could use a pin or a stick.
Understood. With respect to this magazine, can you walk me through the process again of what you did to increase the capacity?
So I used my tooth, not recommended. I had to chew on it for a little bit to finally get it lined up just right. The magazine base plate slid a little, which unlocked the locking mechanism, slid the floor plate off, removed the the locking plate underneath it, slid the spring back in, slid the base plate back on, tried 11 rounds, they went right in. I didn't have to remove any spring on that one.
So what did you change about the magazine if you didn't remove spring?
I removed the locking floor plate.
So you took that piece out of the magazine?
Yep.
Can you describe that piece to me?
It's just a little piece of plastic with a dimple on it that fits in the base plate to keep the base plate from sliding off.
So the purpose of that piece is to keep the base plate secure?
Yep.
Did removing that piece affect the security of the base plate?
Yes.
How so?
So, without it being locked into place, the base plate could slide off. Mostly when it's unloaded. When it's loaded, it's under enough spring tension it would hold it. But if you needed that to be locked, you could bend the spring to take the place of that locking plate and protrude through that hole and hold it into place.
How long did this process take?
That took me about 5 minutes.
Did you try a similar process with any other aftermarket magazine?
I didn't have any other 10-round aftermarket magazines in my shop that I was willing to sacrifice.
When did you perform these modifications?
Saturday. This last Saturday, I should clarify.
Nothing further.
Redirect.
Mr. Callaway, you were asked about the length of time it took to remove the spring coils. Is there a quicker way other than bending the coil back and forth?
Pair of wire cutters.
No further questions.
Thank you. We can sit down, Mr. Callaway. Thank you. Mr. Aiello.
No further witnesses from plaintiffs, Your Honor. I do have one other exhibit I would like to have entered in the record. I expect it will draw an objection, and we'll see where we go from there.
You're good at it. You guys are great at anticipating objections. If we're out of litigation, I'm sure they're going to object to this. Go ahead. Okay, this is Plaintiff's Exhibit 35. Go ahead.
Yes. So, Your Honor, Plaintiff's Exhibit 35 is a statement from former New Jersey Governor Christie regarding some executive orders that would be and other changes regarding their permit to purchase system after the death of resident Carol Bone, who was stabbed to death by an ex-boyfriend against whom she had obtained a protective order. She died waiting for a permit to purchase a firearm after it went beyond 30 days, as the 30-day requirement is consistent between the former the New Jersey permit to purchase program at the time and the Oregon permit to purchase system under ballot measure 114. Plaintiffs believe that this is relevant to the proceedings and is, I'm guessing, on a hearsay objection, and plaintiffs are prepared on the hearsay objection as well.
I'd imagine they'd want it admitted. I'm not going to let it be admitted because it opens up something I've already excluded consistently through these proceedings. So I'm not admitting 35.
And to make our record, we object on the ground. Well, I think as the court just mentioned, the application of on relevance grounds, the court's prior ruling with respect to Dr. Siegel's testimony on the efficacy or public safety implications of other states' permit to purchase policies has been excluded by the court. My understanding is based on relevance. So that ruling would apply equally to this. If the court would reconsider, we would be happy to recall Dr. Siegel on that question, but I don't think the court will reconsider. We will also object on hearsay grounds. We do not believe this is subject to any hearsay exception.
I'll sustain. I'm not reopening permit to purchase. If I open that door, I think I'm bound to open that door, Mr. Aiello. So
Plaintiffs understand your ruling.
sometimes we can be a little dangerous as litigants. I get it. I was a defense attorney for a long time, but I'm going to not allow that. All right. I think just in terms of timing, this is a good time to take a break, and then we'll get to the next piece from you're arrested.
Plaintiff's
The evidence is
restaurant.
closed. Let me just make sure we're all on the same page. Defendant's exhibit list that was submitted is accurate. Just to be clear, accurate in terms of what's been offered and what's been admitted. For the plaintiffs, we have the courts admitted 1 through 3, 6 through 8, 18, 19, 21 through 29. Are we missing anything from the plaintiffs submitted? I'm just reviewing the court's records.
What was 8? I believe you said 18 and 19, and then 21 through 29.
Right.
That is what plaintiffs have as well, Your Honor.
Your Honor, we're confirming that our records reflect the plaintiff's exhibit list, and we'll make sure that if there's any corrections that we offer them over the break.
Sure.
With respect to 105, we marked it this morning prior to the court's exclusion of that evidence. We can refile an amended exhibit list reflecting the court's ruling.
It was unknown, yeah.
Yeah, it was I think we marked it UC as under consideration, and we'll mark that the objection was sustained.
Okay. Fair enough. That's fine. You could make those amendments. Let's take our break, and then we'll come back. I've had the look of the man who was trying to jump up several times before I took us into recess.
Oh, me? Yes.
That's
Yes,
why
Your
I'm
Honor.
looking at you.
We have just a couple of items before we move to closing. First, I'd renew the motion for ORCP 60 directed verdict at this time for the reasons stated in our trial brief, and as we'll argue during closing arguments, would be my first issue. And second, Your Honor, I understand that Mr. Aiello is considering the motion for leave to make offers of proof. I did hope that Your Honor might indulge us in one attempt to clarify our position in the record. With respect to Melissa Breimer, who I believe is number 2, our understanding, Your Honor, is that her testimony is excluded as a result of the motions in limine ruling that the impacts of tragedies on surviving family members is excluded. Dr. Breimer would have testified about her work with surviving family members of Sandy Hook and other mass shootings and provided testimony about that experience and her findings. So we don't understand the court to have excluded her for lack of foundation as an expert witness, but just wanted to make sure that that was clear, that that was our argument, and we understood your court's ruling.
I haven't had a chance to really look at it much. I just saw that the first witness was somebody who was called, and I had already said I wasn't going to accept an offer of proof for him. So that sort of, the remainders, I really haven't looked at it very carefully because I had chores this weekend.
We understand, Your Honor.
Got it. So.
And Your Honor, from plaintiffs, what timeline, by when would the court like a written response?
I think by Monday, next Monday, the 2nd, I'll close the record at that point.
Thank you for the time, Your Honor.
I believe the only other matter is the exhibit list, which Mr. Marshall will.
And we agree with the list of exhibits that the court has admitted that were on the record, plaintiff's exhibits that were admitted.
Thank you. Well, I mean, for a directed verdict, the bottom line is I think there's evidence here to support the plaintiff's positions. I'm going to deny the directed verdict. I believe there's sufficient evidence for the court to weigh on the issues that are in front of it pursuant to the statute. So, are we ready then to proceed to closing argument?
We are, Your Honor.
We are, Your Honor.
All right.
And Your Honor, plaintiffs expect that the court may have questions during closing argument that may require plaintiffs to refer to case law. If I'm incorrect, just let me know. But plaintiffs were wondering if we could sit during closing so we
You can sit. I guess what I intend to do, I mean, this is somewhat of a unique case in respects because we really have two things that have occurred. We have a significant amount of evidence on large capacity magazine issues, not a significant amount of evidence with regards to permit to purchase. I sort of anticipate in the closing arguments focus on both topics, and I think what I'm going to do is I'm going to hear both of you out. I'm going to do my darndest to remain silent. As you've been able to observe, that's hard for me, but I'm going to do my best. And once you're done with your closing arguments, I'll return to both of you with regards to questions in case law and other areas that have not been identified to me through the closing. That's the last you'll hear from me until I ask the other side whether they're ready to make their closing. So go ahead, please.
Thank
you
you,
both
Your
can
Honor.
remain silent. See, I've already failed to keep my mouth shut. You could both remain seated and make your arguments from a seated position.
Thank you, Your Honor. Your Honor, plaintiffs would like to start by thanking the court staff, the sheriff, and the deputies for their transparency, patience, assistance, and accommodations this week. Everyone went above and beyond, and it's much appreciated. Plaintiffs would also like to draw the court's attention to the record in this case, aside from what's been presented at trial, specifically plaintiffs would like to direct the court's attention to 5 responses to requests for admission filed by defendants in this case, the most recent of which was the Friday before trial on September 15th. There's a response to request for admissions from Governor Kotek. There's obviously, Your Honor understands the implications of responses to requests for admissions, that they remove the party's burden of proof on that fact for trial. Plaintiffs, especially regarding the response filed September 15th, Governor Kotek admitted that millions of Americans own so-defined large capacity magazines. So that's one in particular plaintiffs wanted to draw the court's attention to, but there were 4 others filed earlier on in the case that haven't, the plaintiffs address them in their pretrial memorandum, but just wanted to draw the court's attention to those. So as noted in plaintiff's opening, the test required by case law under Article 1, Section 27 provides for 4 steps. Plaintiff's position is that if this court agrees that plaintiffs have met their burden regarding step 1, then the court will reach steps 2, 3, and 4, and failing any one of those steps makes the law unconstitutional. Step 1 is best addressed in Delgado, which is the appropriate inquiry in the case at bar is whether the kind of weapon, as modified by its modern design and function, is of the sort commonly used by individuals for personal defense during either the Revolutionary and post-Revolutionary era, or in 1859 when Oregon's Constitution was adopted. In particular, it must be determined whether the drafters would have intended the word arms to include, in Delgado, the switchblade knife as a weapon commonly used by individuals for self-defense, and that's Delgado 400 to 401. Importantly, neither Kessler, Delgado, nor even Oregon State Shooting Association stand for the proposition that the historical predecessors must have been found in Oregon. In Kessler, the court specifically noted the roots of Article 1, Section 27 in other older constitutions, including those from other states, the American colonies, and even England. Also, Delgado does not stand for the proposition that the firearm or firearm capabilities considered in, or the arm capabilities considered in the law must have an identical counterpart in history. Such a conclusion is counter not only to Article 1, Section 27 case law, but constitutional case law in general. It would also read out of binding case law the allowance of modern designs and functions. Delgado specifically contemplates a switchblade, which, as the court noted, is a knife with technological advancements to add a spring. I'd also like to direct the court to Delgado at note 4. And I'm going to read from that note. Quote, at one time, the single action, single shot handgun was carried by many men for defense. Did the development of the double action feature of the handgun or the addition of the revolving cylinder, which enabled one to fire the gun several times without pausing to reload as a matter of law, transform the handgun from a defensive weapon to an offensive weapon? Obviously, the gun, both before and after such changes, could be used for either defense or offense. Delgado is much broader than defendants read. Delgado seems to expressly contemplate that multi-shot or repeating firearms are protected by the Oregon Constitution. If a change, as Delgado contemplated, from a single shot to a multi-shot firearm would not be such an astonishing change as to make the multi-shot revolver a different sort of arm, then the addition of a few rounds to the 4 or 7 that have been 4 to 7 that all of the experts agree were common in Oregon and in the West and in the United States in the 1850s in the form of the pepper box and the Colt revolvers. The addition of a few rounds is much less astonishing than going from multi-shot to or single shot to multi-shot. In step 2, assuming the court agrees that plaintiffs have met their burden regarding step 1. Step 2, there are 4 decades of consistent Supreme Court case law that makes clear that manner of use and manner of possession laws are 2 of the 3 permissible types of laws restricting firearms. The others come from Cartwright, and that's 246, or 120, and Hirsch, which I will provide that citation later. I do not, I'll just do it now. Let's see here, is State v. Hirsch, which is 338 or 622. That covers the 3rd type of permissible arms restrictions. All other restrictions are per se unconstitutional. So looking at manner of use and manner of possession, that standard was first identified in Kessler. Kessler talks about the English statute of Northampton and a Massachusetts law forbidding shooting in certain areas as examples of manner of use, manner of possession laws. Kessler also cites as examples statutes prohibiting the carrying of concealed weapons and cites State v. Hart, and that's 66 Idaho 217, 1945, and statutes prohibiting the possession of arms by felons. And for that, Kessler cites to State v. Cartwright 246 or 120 at 418, and that's 1966. So those are the 3 types of permissible laws that that Article 1, Section 27 allows for. In Blocker, I'm sorry, Your Honor, I did not put the cites early enough. Blocker, State v. Blocker is 291 or 255. So in Blocker, the court specifically noted, quoting here, our decision in neither case goes to the question of permissible legislative regulation of the manner of possession or of regulation of the use of the billy. Later, the court notes the statute is written as a total proscription on the mere possession of certain weapons, and that mere possession, insofar as a billy is concerned, is constitutionally protected. Also in Delgado, the court again stressed this point, stating, we stress again, as we have stressed before, that this decision does not mean individuals have an unfettered right to possess or use constitutionally protected arms in any way they please. The legislature may, if it chooses to do so, regulate possession and use. The court goes on, this court recognizes the seriousness with which the legislature views the possession of certain weapons, especially switchblades. The problem here is that ORS 166.510 subsection 1 absolutely proscribes the mere possession or carrying of such arms. This the Constitution does not permit. And finally, getting to State v. Christian, which is 354 or 22, here at 29, the Christian court noted that the ordinance at issue had no effect on the manner of possession or use of firearms for self-defense at home. It also did not prohibit the mere possession of firearms in public, and specifically only regulated the manner of possession, and that is defined as being, quote, knowingly possessing or carrying a loaded firearm in public and recklessly failing to remove all ammunition. As the court also noted, it had a carve out for concealed handgun license holders. Nothing in Christian disturbed the then 30-plus year and now 40-plus year unconstitutionality of absolute proscriptions on the mere possession of protected arms. And no level of public safety benefit whatsoever can overcome the requirement that the law be manner of use, manner of possession, or restrict arms possession only to individuals as noted by Hirsch. Those are the only three types of firearm regulations that are allowed under Article 1, Section 27. In defendant's trial memorandum, defendants posit that manner of use or manner of possession includes both whether and to what extent a firearm may be possessed or used. Plainly, whether a firearm may or may not be possessed or used would be an absolute proscription, which is not included, as the case law plaintiffs have just gone over, states. And then restricting firearms to certain dangerous persons, that's the third type of permissible law. Cartwright stands for the proposition that arm ownership can be restricted from felons. Hirsch at 677 spells out the test to be applied. The test is as follows, quote, Article 1, Section 27 does not deprive the legislature of the authority, 1, to designate certain groups of persons as posing identifiable threats to the safety of the community by virtue of earlier commission of serious criminal conduct, and in accordance with such a designation, 2, to restrict, the number 2, and then to restrict the exercise of the constitutional guarantee by members of those groups. Defendants do not cite to any other type of absolute firearm purchase or ownership restriction that has been supported by Oregon's appellate courts. And so plaintiffs assert that those three are ballot measure 114 or its provisions must fit into one of those three categories. Assuming the court disagrees with plaintiffs and moves to the next step of the analysis, for step 3, defendants ask to be heard on public safety and are responsible for proving that ballot measure 114 furthers the stated public safety goals from the preamble. As this court stated, the court has allowed defendants to take up that burden. Christian states that a constitutional restriction upon the manner of possession or manner of use of firearms must be, quote, necessary to protect public safety. And that's Christian at page 31. This demonstrates that the state defendants must show that there is first an issue for the state of Oregon regarding public safety that is in need of address, and 2, that the chosen policy does so address the public safety concern. Hirsch notes that, quote, that is not to say, however, that the legislature's authority to restrict the bearing of arms is so broad as to be unlimited. Rather, any restriction must satisfy the purpose of that authority in the face of Article 1, Section 27, the protection of public safety. Hirsch stands for the proposition that the state defendants must show that the law burdening Article 1, Section 27 rights must actually satisfy the stated public safety goal before it can even be considered as potentially constitutional. This is consistent with the higher level of scrutiny for constitutional rights. Moving to step 4, Article 1, Section 27 guarantees not only the right to bear arms for self-defense, including the defense of person and property such as livestock, but further guarantees the right to bear arms in defense of the state or in self-defense from the state tyranny. As noted in Kessler, the 3 primary justifications for a state constitutional right to bear arms are, quote, A, the preference for a militia over a standing army, B, the deterrence of governmental oppression, and C, the right of personal defense. And that's Kessler 289 or 366. Public safety is what defendants want this court to consider. However, this case is not solely about public safety and instead requires that this court find both that there's a public safety benefit and that the benefit is accomplished without infringing or even unduly burdening the right to bear arms. If a right can be taken away simply because it furthers public safety in some way, it is not a right at all. I'd like to draw the court's attention to McDonald versus City of Chicago. That's 561 US 742. The pin site is 783 in 2010. And in that case, the court cited several types of rights that Oregonians and Americans enjoy that cause public safety concerns. So the McDonald court cites Hudson v. Michigan, 547 US 586. The pin site is 591 from 2006 that states, quote, the exclusionary rule generates substantial social costs. And the court continues, which sometimes includes setting the guilty free and the dangerous at large. The McDonald court also cites Barker v. Wingo, and that's 407 US 514, pin site 522, 1972. And in that case, they reflected on the serious consequences of dismissal for speedy trial violations, which means, quote, a defendant who may be guilty of a serious crime will go free. And then the court also cites Miranda v. Arizona, 384 US 436, 517 of 1966. And cites the Harlan dissent and the Justice White dissent, which objected that the court's rule in some unknown number of cases will return a killer, a rapist, or other criminal to the streets to repeat his crime. These are just a sampling of constitutional rights under the United States Constitution that have related provisions in Oregon's Constitution. And these rights cause public safety concerns. But the government cannot just take away the rights in furtherance of public safety. As your honor knows, these protections, while they can lead to some societal public safety costs, are intended and often do protect the individual against the prosecutorial strength of the government and prevents abuses of accused persons. We do not weigh the rights of the individual in these instances against the rights of the individual accused against the social cost. Likewise,
I was sitting up.
oh, understood. Likewise, the court will not find any justification for any interest balancing analysis in the case law cited by the parties regarding Article 1, Section 27. The court must consider separately whether there's a sufficient showing of a benefit to public safety and whether there's an undue burden or infringement on the right to bear arms for the purposes identified in Kessler. This court also noted that the court would like some argument on what self-defense means. Oregon has maintained a substantially unchanged standard for self-defense since 2 years after its founding. And this can be found in Goodall v. State, and that's 1 or 333 at 337 to page 338, and that's an 1861 case. In that case, the court found that Oregonians have the right to use deadly force in self-defense when they believe that they or another person are in danger of death or great bodily harm and that such harm was imminent. Imminence is key in self-defense. Article 1, Section 27 also allows you to be protected not only for defense of yourself and others, but also to protect livestock and other property. This is supported by Kessler at page 367 when the court referred as a justification for Article 1, Section 27, the quote, exigencies of the rural American experience, as well as persuasive case law cited in plaintiff's trial memorandum, specifically Heller, and that's 254 US 570 at page 628. Article 1, Section 27 also allows Oregonians to protect the state and protect themselves from state tyranny. Again, that's Kessler at 366. Plaintiffs suggest that these considerations remain in place today, just as they did in 1857, notwithstanding how the state, this country, and this world has changed over 165 years. This court will have to decide whether the law unduly burdens or infringes upon these rights. Laws that restrict the use of arms, including firearms, for the purposes identified in Kessler, per se, frustrate the right to bear arms. The question is the degree to which they frustrate the right to bear arms. Laws that totally restrict the use of arms, including firearms, for these purposes absolutely infringe on the right to bear arms. So if a protected arm is not allowed to be used for self-defense, it is a per se infringement. Laws that restrict the use of arms for other purposes, such as while hunting game, do not burden, frustrate, or infringe on the right to bear arms, because hunting is not among the purposes for which this right was guaranteed to us. It's guaranteed for self-defense, it's guaranteed for defense of others, it's guaranteed to defend the state, and it's guaranteed to defend from the state. This is why laws that restrict the number of rounds that you can use while hunting in order to be sportsmanlike are allowed under Article 1, Section 27. The question before this court is not whether the burden is undue. The question before this court is whether the burden is undue on self-defense and defense of the state, not whether it is undue in light of the proposed public safety benefits, because there is no interest balancing test in Oregon. So that takes us to a look at the evidence that the court heard this week regarding step one. Plaintiffs would first like to address step one. In plaintiff's trial memorandum, plaintiffs assert that this court can decide step one regarding all aspects of ballot measure 114 without receiving any evidence. The reason is that, pursuant to Christian, the court need not engage in a firearm by firearm, make by make, and model by model analysis where the law broadly applies to all firearms or such a vast majority of firearms as to make an arm by arm analysis untenable. Christian concerned a law against public carry of a recklessly loaded firearm. The law, by its terms, applied to all firearms. The Christian court did not say, well, this law is constitutional as it's applied to certain firearms, but unconstitutional or potentially unconstitutional as applied to others. The court went straight to the second step of the analysis. This distinguishes ballot measure 114 from the law considered in Oregon State Shooting Association. The facts of Oregon State Shooting Association are covered at length in plaintiff's trial memorandum. Defendant's memorandum filed last night misstates the facts of Oregon State Shooting Association as broadly applying to many different semi-automatic or so-called assault weapons. However, to briefly recount the facts, the case in Oregon State Shooting Association concerned a specific list of firearms which could be independently analyzed for their historical predecessors, as well as how that individual firearm was developed. I'm going from rote here, but I believe the total number of firearms banned in the case of Oregon State Shooting Association was 25. So there, the court can look at how each one of those specific firearms was developed and the technology that underlied them and make a determination on whether those arms are protected. That is not the case in regarding ballot measure 114. This is also similar to prior case law that only concerned really specific weapons like the switchblade. So it's easy to look at one arm and determine whether that arm has a historical predecessor. When a law applies to all firearms, as does the permit to purchase program and the magazine ban. Such an analysis is not necessary. It would also be ridiculous for this court to engage in a firearm by firearm analysis of each and every firearm that has been created since 1859 and have the parties come back every time a new firearm comes out. Here, the law broadly applies to all firearms, and the court should move to step 2. This is true as well for the permit to purchase program. This question, conveniently for the court, was answered by the parties' fourth stipulation that the law applies to all firearms as defined under the statute. For the magazine ban, the plain text of the ban applies to all ammunition feeding devices contained in all firearms, whether those firearms utilize a fixed or detached ammunition feeding device or magazine. Defendants have not produced for this court any red apples supporting their interpretation. The only exceptions were noted by plaintiffs and unrebutted by defendants. And those 3 come from section 11(1), little d, big A through C, and that's page 26, line 16 to page 27, line 2 of the text of the measure defendants have submitted to the court. So large A covers so large A covers, quote, an ammunition feeding device that has been permanently altered so that it is not capable now or in the future of accepting more than 10 rounds of ammunition. As Mr. Springer has shown this week, no magazine is capable of meeting this test. Dimples don't work, rivets don't work, spacers don't work, and epoxy cannot withstand a hammer, heat gun, or even a pot of boiling water. Moreover, Mr. Springer discussed the adverse effects such modifications have on the ability to maintain magazines and how disruptions can occur in the firearm operation when the internals of the magazine are tampered with. The second exception is for 22 caliber firearms that utilize a tubular magazine. And that comes from 11(1)(d)(b). As has been testified by Mr. Springer, Defendant Cotting, Mr. LeBlanc, Sheriff Bowen, and Sheriff Jenkins, larger calibers are preferable for self-defense. The third exception is for lever action firearms utilizing a tubular magazine, and that comes from large C. As has been noted by Professor DeLay and Mr. Springer, this definition does not include pump action shotguns, which are commonly among the firearms recommended for home defense. Further, plaintiffs have shown that the limit on capacity applies to any and all firearm actions. You heard from Mr. Springer and Mr. Callaway concerning firearms covering semi-automatic, pump action, bolt action, and even revolver firearms that utilize fixed or detachable magazines that exceed 10 rounds. Plaintiffs would direct the court to Exhibit 28. In Exhibit 28, there are 3 bolt action rifles, the top 2 of which accept a detachable magazine. The bottom of which Mr. Springer described as a classic hunting rifle. I believe it was the Remington 700, the one it was made of wood. And Mr. Springer described how that firearm can be modified to accept a detachable magazine, such that the magazine ban applies to bolt action, semi-automatic, revolvers, pump actions, many different types of actions. So looking at specifically semi-automatic firearms, that's not all this law applies to. Mr. Springer also specifically testified to a revolver that accepts more than 10 rounds. I believe it was 12 rounds. And that testimony shows that that the restrictions on magazines would apply to the revolver as well. You also heard from Mr. Callaway concerning the broad reach of this ban as applying to approximately 90% of the handguns he sells. More importantly, defendants have put forth no evidence disputing the broad applicability of Ballot Measure 114's magazine ban as applying to all firearms, regardless of the type of action they utilize. So that was all regarding why this court should move directly to the next step of the analysis without considering the expert historians. Assuming this court disagrees, the test from Christian, since Christian does not engage in a firearm by firearm analysis, the best case for this court to look at is Delgado. In State v. Delgado, the court stated, quote, Article 1, Section 27 is not limited to firearms, but protects all arms which, as modified by their modern design and function, are of the sort commonly used by individuals for personal defense during either the Revolutionary and post-Revolutionary era or in 1859, when Oregon's Constitution was adopted. Delgado does not say that the arms must have been demonstrated to be in Oregon. It would be such a conclusion wouldn't make sense because the court instructs to look at the Revolutionary period, which is decades before the Louisiana Purchase and nearly 100 years before Oregon's Constitution was adopted. In fact, the Supreme Court in Kessler noted that the court should look at Oregon's constitutional roots in Indiana, Kentucky, Ohio, Tennessee, Pennsylvania, and the American colonies, as well as the English Bill of Rights. So Kessler instructs the court to look much further than just what was in Oregon in, I would say, the 2 years since the Constitution was drafted until it was adopted in 1859. Even under Oregon State Shooting Association, which plaintiffs have asserted is completely distinguishable, the Court of Appeals never said that the arms had to be in Oregon. As formulated by the Supreme Court, the inquiry is whether the weapon is within the meaning of arms from Article 1, Section 27, and the court should consider its modern design and function when determining whether it is of the sort commonly used by individuals for personal defense. Looking at Oregon State Shooting Association, it is distinguished in several regards. First, in that case, the court considered a specific list of firearms, unlike the record before this court and the court in Christian. Second, as addressed in our trial memorandum, the facts underlying the Oregon State Shooting Association opinion concerned so defined assault weapons, not firearms capable of firing more than 10 rounds. And third, there was a specific finding of fact in the Oregon State Shooting Association case that the listed firearms banned in that case were apparently developed from military firearms that utilize select fire. There is no such record before this court regarding firearms capable of holding more than 10 rounds. Further, plaintiffs expect defendants to assert that plaintiffs have failed in demonstrating that arms capable of holding more than 10 rounds existed during this period. But again, that is not the test. The court should instead look at whether multi-shot or repeating firearms capable of firing more than one round without reloading meet the test. Delgado specifically contemplates technological changes that were much more astonishing than the addition of a few rounds to an already repeating firearm. Defendant's test is unbelievably strict and not in line with other constitutional rights. Defendant's test would allow any modern firearm to be banned since modern firearms utilize metallic cartridges, for instance, which can be loaded much more quickly than antiques. Regardless, plaintiffs have shown multi-shot and repeating firearms of various capacities, including those over 10 rounds, over the course of 600 years of history. Ms. Sablinski, Professor DeLay, and Professor Taveskov all agree that Oregon's founders were well aware of Colt revolvers and pepper box revolvers. They all agree that these were repeating firearms capable of holding 4 to 7 rounds. The addition of 3 rounds is hardly more astonishing than the addition of a spring to a switchblade, especially when considering the technological changes in weaponry that were occurring in the 1850s. Ms. Sablinski and Professor DeLay both agree that there were varieties of pepper box firearms that held more than 7 rounds, but antique design flaws, namely the weight of the firearm and the desire to conceal the pepper box firearm, caused the free market of firearms to favor a lighter weight and concealable design. Ms. Sablinski and Professor DeLay also agree that firearm styles such as the Kalthoff and the Lorenzoni style firearms were readily available to those who could afford them long before Oregon became a state. Ms. Sablinski, Professor DeLay, and Professor Taveskov all agree that immigrants on the Oregon Trail had access to these firearms and that they were commonly used for self-defense and defense of the state in Oregon and outside of Oregon. Ms. Sablinski and Professor DeLay also agree that multi-shot and repeating firearms technology had developed over some 600 years of firearm history in Europe to the colonies and then to Oregon. Ms. Sablinski testified as to numerous examples of multi-shot and repeating firearm technology over this period, and further testified to the importance of looking at whether a firearm style was copied as an early form of commercial success. Professors DeLay and Taveskov's primary issue with these firearms is that they were inferior in design and function due to their antiquity. However, Delgado requires the court to account for improvements in modern design and function. Further, both Ms. Sablinski and Professor DeLay agree with Mr. Springer that firearm magazines do not constitute, Further, Ms. Sablinski and Professor DeLay agree with Mr. Springer that firearm magazines are a part of the firearm, an integral part of the firearm, and are not mere accessories. Moving to step 2, Your Honor. This one's shorter. So looking at manner of use and manner of possession laws. The parties have stipulated that this step, the step of determining whether any provision of ballot measure 114 is a manner of use or manner of possession law, is a question of law, and that's stipulations 2 and 3. Use of the word manner presupposes that the possession or use, or the mere possession or mere use of the arm is permissible, but places restrictions on how or the manner in which the arm is possessed or used. The most consistent and contextual dictionary definition of manner is a, quote, mode of procedure or way of acting. And for that, plaintiffs would cite to Lovelace versus Board of Parole and Post-Prison Supervision 183 or App 283. That's a 2002 case defining manner in that way, and citing to Webster's Third New International Dictionary, 1376, the unabridged edition in 1993. Plaintiffs would also note that dictionary definitions to discern the plain, natural, and ordinary meaning of words is routinely used by the appellate courts. For the permit purchase program, the plain text of ballot measure 114 indicates that it does not regulate any mode of procedure or way of possessing or using a firearm. It affects the mere acquisition of the firearm, which is necessary for the mere possession of the firearm. It prevents the mere acquisition of a firearm by making any Oregonian who has not submitted to a background check, taken the state's test, passed the test, and not been found to present reasonable grounds for a permit agent to not issue the permit to do all these things before the Oregonian can acquire a firearm. Plaintiffs assert that preventing the mere acquisition of a firearm is the functional equivalent of an absolute prescription on the possession of a firearm. If you can't buy it, you can't possess it. This is especially true for new firearm purchasers and those who do not receive them from family. Pursuant to Delgado, the Constitution does not permit. Indeed, plaintiffs assert it is an even greater infringement than that contemplated in Delgado, which concerned one type of arm, the switchblade, but allowed other knives. Here, all firearms are subject to this absolute prescription. The same is true for the magazine ban, which is an absolute prescription on the possession or use of these arms. Allowing an affirmative defense does not change the fact that the act itself is still illegal. There's just an affirmative defense if the Oregonian can demonstrate the affirmative defense. Unlike Christian, the ballot measure 114's magazine restrictions are not limited to public carry, and there's no carve out for those licensed to conceal a firearm. Again, plaintiffs assert that the court need not go any further than this prong. Case law does not allow for an absolute prescription on any arm, regardless of the public safety benefit. There is no level of public safety benefit that can avoid this prong. Likewise, the plain text of ballot measure 114 applies to all Oregonians, regardless of their criminal histories. The parties have stipulated that this is a question of law, and that's stipulation number 3. Pursuant to Hirsch, this law does not designate any certain group of persons as posing an identifiable threat due to their earlier commission of serious criminal conduct, nor does it restrict the possession of firearms or any specific type of firearm to those persons. A duplicative background check does not meet that definition. Fingerprints do not meet that definition. An educational course does not meet that definition. An in-person demonstration does not meet that definition. And a subjective mental health check based upon reasonable grounds to support denial does not meet that definition. Allowing the denial of a permit to purchase to persons who have never been convicted of a crime does not meet that definition. Paying $65 does not meet that definition. A gun registry does not meet that definition, and no part of the permit to purchase program meets that definition. That takes us to step 3. The third step of the analysis is to determine whether defendants have met their burden of showing that Measure 114 will actually further public safety with regard to an identifiable public safety goal. This was an opportunity defendants specifically asked this court to require of them, and plaintiffs assert that defendants have failed in this endeavor. Plaintiffs note that defendants have put on zero evidence showing that restricting a regular law-abiding Oregonian from the best arms for self-defense will further public safety in any way. Defendants' entire public safety theory regarding the magazine ban rests on the unsupported theory that a mass shooter who is forced to reload could be stopped by bystanders. Meanwhile, plaintiffs have shown through several witnesses that the rate of changing out magazines tends to be between 1 and 5 seconds. Exhibit 1 shows fewer than 3 seconds. As stated by Ms. Sablinski, the number of 10 rounds is historically arbitrary. Moreover, the number of 10 rounds is presently arbitrary, as well as within the small minority of states enacting various forms of apples, as this court has characterized it, none of which are as strict as that imposed by the state of Oregon. So I'd like to look here briefly at the definition of a large capacity magazine.
Okay, go ahead. I'm sorry, I was not going to interrupt. Without an objection. Sorry, go ahead.
So looking at the definition of large capacity magazine, plaintiffs have asserted that the definition limits Oregonians not to 10 rounds in the magazine, but 9. This is because, as this court heard evidence, their magazines are typically characterized as the number within the magazine plus the 1 round that can be placed in the firing chamber of the firearm. This court also saw evidence in her testimony regarding ghost loading of shotguns that would make that inquiry a +2 inquiry. The laws provided to this court by defendants are not red apples. They do not have the same definition of large capacity magazine, and I'd like to direct the court to the specific provisions within section 11(1)D that cause this issue. The first one is that none of the laws cited by defendants include the phrase including any such device joined or coupled with another in any manner, or a kit with such parts that has an overall capacity of, or that can be readily restored, changed, or converted to accept more than 10 rounds of ammunition and allows a shooter to keep firing without having to pause to reload. Plainly, a magazine inserted in a firearm, when a magazine is inserted into a firearm, it is joined or coupled with the firearm, which is a device, in some manner. The law covers any manner. Regarding the issue of extensions, the laws cited by defendants do not include that language or the language or a kit with such parts. They also do not include the phrase that has an overall capacity. So the overall capacity is what this court should be looking at. They also don't have subsection D big A, which says an ammunition feeding device that has been permanently altered so that it is not capable now or in the future of accepting more than 10 rounds of ammunition. The laws cited by defendants are not red apples, and they do not go nearly as far as ballot measure 114 does. This court saw evidence of how firearm distributors understood a device joined or coupled with another in any manner or kit with such parts. Plaintiffs assert that if this court searches every single state that has the laws provided by defendants, the court will not find that language, which is why Mr. Urgielitis was able to buy these firearms and these magazines in those states. Additionally, the number of 10 rounds is historically arbitrary, as testified by Ms. Hiblinski, and is presently arbitrary as well. Delaware has a 17-round magazine limit, and the court can look at Delaware State Sportsmen's Association Incorporated versus Delaware Department of Safety and Homeland Security, civil action number 22-951-RGA 2023 U.S. District Lexus 51322 at page 4, and that's District of Delaware as of March 27th, 2023. The court can look at Illinois and Vermont's 15-round limit for handguns and rifles. That comes from 720 ILCS 5/24-1.10, subsection A, and Vermont statutes annotated Title 13, Section 4021. Colorado has a 15-round limit for handguns and rifles and a 28-inch tube limit for shotguns. That's Colorado Revised Statute annotated section 18-12-301. And then yesterday, California's 10-round limit was struck down. That's Duncan v. Bonta, 17-CV-1017-BEN. So these states have various levels of capacity that are allowed. There's nothing significant or special about round number 10. Defendants justify this law using statistically insignificant sample sizes that they represent to this court as showing that Oregonians do not need more than 2.2 rounds to defend themselves. They say that the average hypothetical person in the average situation needs no more than 3 rounds. But statistics mean nothing to the individual who has a wide range of strengths and weaknesses, disabilities and specialities, skill with a firearm or lack thereof, or the innumerable self-defense scenarios in which individuals may and do find themselves. Statistics mean nothing to the person whose door is kicked in by more than one attacker. Statistics mean nothing to the person who hears the howl of a wolf or coyote, and statistics mean nothing to the officer whose ability to defend himself and others differs based on whether he is punched in or punched out for the day. Defendants have failed to carry their burden regarding public safety that they specifically requested. That brings us to step 4. The fourth step of this court's analysis is to determine the extent of the burden placed on Article 1, Section 27 rights under the law. So let's look at the permit to purchase program. The permit to, and Your Honor, I understand this court's ruling to be that we can talk about 30 days. If I'm incorrect, either defendants or the court can please let me know. But my understanding is that when we're looking at infringement, the timing of 30 days is what this court is considering. Are plaintiffs incorrect?
That's the language that's written into the statute, and that's our understanding of the court's ruling.
Okay, thank you, Your Honor. I didn't want to.
I just said, yeah, yes.
Understood. So the permit to purchase program only grants due process at 30 days. You heard from Sheriff Jenkins that he has been threatened due to his status as a public official. Thankfully, Sheriff Jenkins has access to effective firearms with more than 10 rounds. However, I'd like to borrow a bit from the facts of Town of Castle Rock versus Gonzalez, and that's 545 U.S. 748, and that's a 2005 case. That case generally stands for the proposition that no U.S. citizen has a constitutional right to law enforcement services and constitutional right to, and law enforcement has no legal obligation to prevent harm to others. In Town of Castle Rock, several weeks after a state trial court in Colorado had issued a wife a restraining order requiring her estranged husband to at all times remain at least 100 yards from the home in which the wife and the couple's 3 daughters resided, the husband allegedly removed the children from the home and killed them. Now imagine the wife gets a threatening phone call from her ex-husband, or a public official like Sheriff Jenkins receives a threat and wants to purchase a firearm, but they can't because they have to engage in testing, which takes an unspecified length of time, and then wait up 30 days for their permit to purchase before they have a right to challenge a delay or denial. If someone is threatened, they have the right to obtain a firearm quickly to protect against imminent harm. The court heard testimony from Professor Tveskov about how long it took Oregonians to obtain a firearm around the time of the founding. Those limitations, as Professor Tveskov also testified, applied to sending a letter to their congressman in Washington, D.C. That's not the standard in which we determine rights on whether or not the supply chain allows for it or whether mail can travel. By that logic, one could not send a letter, or one could be restrained from sending a letter to their to their congressman in Washington, D.C. for months, as Professor Taveskov testified. Email would have to be disallowed. Tweeting or posting on X would have to be would be capable of being disallowed, because Oregonians did not have the ability to send a letter very quickly in 1859. However, what this court heard is that when the supply chain did provide, an Oregonian in as little, even from rural, more rural areas of Oregon, could obtain a firearm by as little as a half-day travel by horseback. That a half day is much less than the 30 days provided for in ballot measure 114. Moreover, this court heard testimony that Oregon today, much like it was in the 1850s, Oregonians are have a right to be able to defend themselves. This court heard from Mr. Callaway and even Sheriff Jenkins and Sheriff Bowen that law enforcement is not always able to quickly reach those who need help despite their best efforts. The court will recall Mr. Callaway testifying that he called 911 emergency and was informed that that no one was available for 5 hours. There's also the issue of discretion when it comes to permit agents. Permit agents are clothed with unlimited discretion to determine whether someone presents, quote, reasonable grounds that they are a danger to themselves or others, and thus deny a permit. There's no requirement that this law be applied in a non-discriminatory manner, and the Oregonian is forced to demonstrate their right to that permit. This presents potentially even further delays beyond the 30 days, because 30 days is when you get your due process rights. Plaintiffs are not nearly as well versed in criminal law as Your Honor, but plaintiffs do assert that forcing Oregonians to choose between their right to bear arms and their right to not be compelled to give their fingerprints forces Oregonians to choose between their Article 1, Section 9 and 27 rights. This is both an infringement under Article 1, Section 27 and a violation of Oregonians' rights under Article 1, Section 9. Turning to the magazine ban's undue burden, defendants assert that so defined large capacity magazines are not useful for self-defense. The court has heard testimony from Mr. Callaway and about law enforcement's unavailability for 5 hours, and he used an AR-15 to potentially protect the people of Burns from someone breaking into a gun store where guns and ammunition are available. Thankfully, that was not the case. The court heard from Sheriff Jenkins and Sheriff Bowen regarding the safety and self-defense concerns for rural Oregonians who are sometimes hours away from responding law enforcement, and that they will likely have to fend for themselves. The court heard from Sheriff Jenkins, Sheriff Bowen, and Defendant Superintendent Casey Cotting and Mr. Springer about law enforcement's favor for larger capacity firearms. Sheriff Jenkins, Sheriff Bowen, and Defendant Cotting all testified that they and their deputies and officers protect themselves as well as their communities with 17+1 9mm semi-automatic pistols and issue extra magazines such that they have no fewer than 52 rounds of handgun ammunition on them. In addition, all three also testified to having duty-issued semi-automatic rifles such as the AR-15 that utilized 20 to 30 round magazines. The court also heard from Mr. LeBlanc, who made the exact same recommendations for Oregonians as did Sheriff Jenkins and Sheriff Bowen. Larger caliber, appropriate for the user, and as high a capacity as is practicable for the self-defense situation, which can most certainly vary based on whether one wants to use a concealed handgun or whether they in public or whether they are in their homes where concealability is not a concern. The court also heard from Sheriff Bowen detailed 2 harrowing stories about how these firearms saved his life. Sheriff Bowen testified that when confronted with several wolves, he used a so-defined large capacity magazine to defend his life. How many rounds did he fire? And he said all 30 of them. The court also heard how civilians support Sheriff Bowen and his deputies out in Union County, including concealed handgun license holders and civilians who utilized semi-automatic rifles. The court heard from Sheriff Jenkins, speaking in his former capacity as a cowboy or buckaroo, testifying to using so-defined large capacity magazines to defend livestock from coyotes and other predators. This was also true of Mr. Otley. The court heard from Mr. Springer about the impossibility of maintaining magazines utilized in outdoor environments without the ability to remove the base plate. The court heard from Mr. Otley as well about the importance of so defined large capacity magazines to keeping his firearm clean and operational to protect himself and his livestock while driving in the dirt, gravel, snow, and mud. The court also heard from Sheriff Bowen testify as to the increasing predator problem in Union County, and Sheriff Jenkins talking about predator problems here in Harney County, including the wolf attack on Mr. Coleman Lay's dog. For defense of the state, the court heard from Professors DeLay and Taveskov concerning Oregon settlers' use of the most advanced weaponry available to them, including Colt revolvers and pepper box revolvers, and their use in wars with Native Americans. This, plaintiffs assert, and the professors seem to plaintiffs agreed and disagreed, was more akin to the defense of the state than it was typical self-defense. The court received evidence and took judicial notice of several facts concerning World War II, showing that Oregon civilians were called upon to be ready to defend the state when Oregon's National Guard was deployed during World War II. Exhibit 7 shows that Governor Sprague expected his civilian Oregon State Guard to be capable of resisting invasion, preserving internal order, and meeting grave emergencies beyond the capacity of state and local police forces. Those individuals were also expected to bring their own arms. The court heard from Ms. Ablinski that the arms available to these Oregonians included the same arms to which the military had access, including semi-automatic firearms. The possibility that Oregon may need her armed citizenry is ever present in an ever-changing and tumultuous world. Oregon, being a coastal state, is an obvious location for a potential invasion. 165 years ago, and building on the Second Amendment enacted decades before, the first citizens of the state of Oregon chose that a well-armed citizenry would be needed to protect this state. But this idea is not so outdated as defendants would suggest. The court heard evidence that still today, Oregonians are assisting law enforcement by protecting not only themselves, such that they don't need law enforcement, but also assisting law enforcement. Plaintiffs ended their opening statement by telling the court that this case is not about public health, public safety, or public concern, but about the individual right to self-defense and the right to bear arms to engage in self-defense, and how that right will fare against the might of the Oregon state government. Plaintiffs have shown that the need, which provided the original justification for Article 1, Section 27, is just as crucial today as it was 165 years ago. More importantly, plaintiffs have shown that these individual rights still matter, and that there are still Oregonians willing to go to bat for those rights in court against the might of the state. Plaintiffs are confident in the record that we have provided this court and ask that this court strike down each and every section, subsection, and syllable of Ballot Measure 114. Plaintiffs ask that this court declare Ballot Measure 114 unconstitutional in its entirety and permanently enjoin it. Plaintiffs assert that the record requires this ruling, common sense requires this ruling, and most importantly, Article 1, Section 27 requires this ruling. Thank you, Your Honor.
Thank you. So it is 11:50. I have a meeting at noon. I think it's probably best if we take up your closing this afternoon. Let me just look at the court's calendar to make sure I know when we should have you back, ready to begin. 1:30. 1:30. Thank you.
Thank you, Your Honor.
Good afternoon, everyone. Please be seated. Good afternoon. So I will start by thanking our President, Joe Biden, for his long-standing leadership in the fight to save lives from gun violence. I also want to thank my husband, the second gentleman of the United States, and the extraordinary members of our administration, the members of Congress, survivors, advocates, and our incredible young leaders who raise their voice and demand change. So we are all gathered here today for a simple reason. We agree that in a civil society, the people must be able to shop in a grocery store, walk down the street peacefully in a classroom, and be safe from gun violence. But instead, our nation is being torn apart by the tragedy of it all, and torn apart by the fear and trauma that results from gun violence. Recently, I have met with students on college campuses across our country. And when I'm there, every time I turn to the students and I make a request of them, And what I ask is, please raise your hand if you have had an active shooter drill while you were in elementary or middle school. Every time, a sea of hands goes up. Because in today's world, on the first day of school, students, yes, learn the name of their teacher. Yes, they learn the location of their cubby. And they learn how to quietly hide from an active shooter. In fact, when having this conversation, a student once told me, "I don't like going to fifth period." "Why, honey?" I asked. "Because in fifth period, there's no closet." In our country today, 1 in 5 people has lost a family member to gun violence. Across our nation, every day, about 120 Americans are killed by a gun. And while this violence impacts all communities, it does not do so equally. Black Americans are 10 times more likely to be victims of gun violence and homicide. Latino Americans, twice as likely. And as a former courtroom prosecutor, I will tell you, I have personally prosecuted homicide cases. I have seen with my own eyes what a bullet does to the human body. We cannot normalize any of this. These are not simply statistics. These are our children, our brothers and sisters, our mothers and fathers. As a former district attorney, attorney general, and U.S. senator, and now as vice president of the United States, I have grieved with parents who have lost a child. I have comforted children who have been traumatized by losing a parent or a sibling. We owe it to them and to those living in fear to act without delay. And on this issue, we do not have a moment to spare, nor a life to spare. And here's the thing, solutions do exist. It's a false choice to suggest you either have to choose between supporting the Second Amendment or passing reasonable gun safety laws. That's a false choice. President Biden and I believe in the Second Amendment, but we also know common sense solutions are at hand. So I'll close with just a couple points. First, President Biden and I continue to be deeply inspired by the students who are leading this movement. So many of whom are here. And second, in so many ways, we are then propelled by their work, by your work. And being propelled by what you are doing, we are expanding our work. With this new office, we will use the full power of the federal government to strengthen the coalition of survivors and advocates and students and teachers and elected leaders to save lives and fight for the right of all people to be safe from fear and to be able to live a life where they understand that they are supported in that desire and that right. And with that, I will now introduce a national leader on this issue. He was only 15 years old when he joined this movement. He is an organizer, he is an advocate, he is a coalition builder, and he is the first Gen Z member of the United States Congress. Representative Maxwell Ross.
It feels good to be a part of a winning movement. Good afternoon, and thank you, Vice President Harris, for the amazing introduction. It's the honor of a lifetime to be here today as President Biden cements his legacy as one of the fiercest champions of gun violence prevention. President Biden and Vice President Kamala Harris. I'm Congressman Maxwell Alejandro Frost, proudly representing Central Florida in the House of Representatives. As the youngest member of the United States Congress and first member of Gen Z, I'm often asked what got me involved in this work, and the answer is quite simple. I didn't want to get shot in school. I was 15 years old when a shooter walked into Sandy Hook Elementary School and murdered 20 children and 6 teachers. And like millions of kids, I went to school the next day with anxiety and fear that my life would be taken, my friends' lives would be taken, and my family's life would be taken by senseless gun violence. Right before I was elected to Congress, I served as the National Organizing Director for March for Our Lives, a movement that inspired young people across the nation to demand safe communities. And we came together, Everytown, Brady, Newtown Action Alliance, Gifford, Sandy Hook Promise, Moms Demand Action, Change the Rep, the Community Justice Action Fund, and so many on-the-ground organizations that have been doing this work for decades. It's because of that steadfast, passionate organizing that we are a winning movement. But we're a winning movement doing very difficult work, because the brutal truth is usually when the most people are paying attention to our movement, it's usually coupled with carnage and death. But not today. Today, the country sees us here at the White House with a president who is taking action. My very first bill as a member of Congress was to introduce the Office of Gun Violence Prevention Act of 2023. To bring together a federal coordinated response on this issue. And today, that bill and our ask as a movement will become a reality due to the executive action and leadership of President Biden and Vice President Harris. See, the president understands that this issue, especially for young people, especially for marginalized communities, is a matter of survival. He's a president who's been fearless enough to reject the gun lobby and sign into law the first major federal gun legislation passed in nearly 30 years, the Bipartisan Safer Communities Act. And look, this action, that legislation comes from love. From Pulse to Parkland, we fight because we love. From Breonna Taylor to Trayvon Martin, we fight because we love. From Tiana Major, Joaquin Oliver, Jamie Guttenberg, we fight because we love. Because when you love somebody, you want them to live free of gun violence. That is what true freedom is. And President Biden wants that safety and freedom for every American. And if this week has shown us anything, because the White House has been very busy this week, it's that Joe Biden wants to be and is a president that understands the power of young people. A president fighting for the world that we deserve. Today, as this administration announces yet another piece of groundbreaking action in the fight to save lives, I am proud to introduce the President of the United States of America, President Joe Biden. Yeah!
Thank you. Everyone should see it except Mom and Dad. Mom and Dad, stand up. I want everybody to see the parents who are proud. You did a heck of a job. Congressman Frost, thank you for the introduction, and you've helped power movement that's turning a cause into reality. You know, you're the big reason why I'm so optimistic about America's future. So many engaged young people. So many engaged, I remember when I was young. We have something in common. I got elected to the Senate when I was 29 years old. Only difference was he was eligible when he got elected to take office. I had to wait 17 days to be eligible. That was 827 years ago, but it was a while. Folks, Vice President Harris, members of the cabinet, so many members of Congress who are here, and relentless leaders on this critical issue. You know, one of the members who couldn't be here today is a really important member, Senator Chris Murphy. With Chris, who together with Congressman Frost introduced the bill, created a dedicated gun violence prevention office, he couldn't be here today. since the tragedy in Sandy Hook, and I remember being there. I remember that, how I met with every one of the parents here. I met with every member, every family. What I do also remember is that, I remember as we're leaving, the state police doing the investigation asked Senator to meet with me, if I could meet with you. And I said, of course I would. And I think there were about 12 to 14 of them. I walked in the room, and two of them started crying. They said, we need help. We need help. I looked at them, I said, what can I do? They said, we need psychiatric help. We need help. We need help. Anyone who doesn't think that these kinds of engagements have a permanent effect on young children, in many cases older their entire lives if they never had a bullet touch them, misunderstands. These were hard and tough cops asking me, could I get them psychiatric help? To all the state and local leaders and advocates from all across the country, and to the survivors and families who are with us today, many of whom Jill and I have gotten to know. And by the way, our losses may be different circumstances, but I know events like this are really hard to attend. I want to be here to promote the change. It brings back all the memories as it happened today. I thank you, those of you who are parents, for being here, brothers and sisters for being here. It matters. You have absolute courage. You found purpose in your pain. Because of all of you here today, all across the country, survivors, families, advocates, especially young people who demand our nation do better than protect all, who protested, organized, voted, and ran for office, and yes, marched for their lives. I'm proud to announce the creation of the first ever White House Office of Gun Violence Prevention. First office created by executive order, I determined to send a clear message about how important this issue is to me and to the country. It matters. Here's why. After every mass shooting, we hear a simple message. The same message heard all over the country. I've been to every mass shooting. Do something. Please do something. Do something to prevent the tragedies that leave behind survivors who will always carry the physical and emotional scars. Families will never quite be the same. Communities overwhelmed by grief and trauma. Do something. Do something. My administration has been working relentlessly to do something. To date, my administration has announced dozens of executive actions to reduce gun violence, more than any of my predecessors at this point in the presidency, and they include everything from cracking down on ghost guns, breaking up gun trafficking, and so much more. And last year, with your help, I signed into law the Bipartisan Safer Communities Act, the most significant gun safety law in almost 30 years. It strengthens background checks, expands the use of red flag laws, improves access to mental health services, and so much more. This historic law will save lives. It's really an important first step. And by the way, I was the guy, along with a woman in California, who once banned assault weapons and mobile magazines. We're going to do it again. We're going to do it again. Call that the reason to hope, because for so long, the conventional wisdom was we'd never get any Republicans to support gun safety legislation. But we did. For the first time in 3 decades, we came together to overcome the relentless opposition from the gun lobby, gun manufacturers, and so many politicians opposing common sense gun legislation. And we beat them. We did it through a bipartisan effort that included a majority of responsible gun owners. We're not stopping here. Again, I'll say it again. I'm not going to be quiet until we get it done. It's time to begin to ban assault weapons high capacity magazines. If you need 80 shots in a magazine, you should own a gun. Because look, last time we did it, it worked. We also, last time we established universal background checks to require safe storage of firearms. It's time. It's time. Look, while we push for Congress to do more, we're going to centralize, accelerate, and intensify our work to save more lives more quickly. That's why this new White House Office of Gun Violence Prevention is what it's designed to do. It will drive and coordinate a government and a nationwide effort to reduce gun violence in America, and will be overseen by an incredible vice president who understands. That's not hyperbole, that's a fact. She's been on the front lines of this her entire career. As a prosecutor, as an attorney general, and as a United States Senator. Her deep experience will be invaluable for this office. And Steph, where's Steph Feldman? Steph, I want you to stand up. Steph Feldman. Been working on this with me since Sandy Hook in 2012. Now, she was 13 years old when she joined me, but in 2012, will serve as director of the office. The office will have 4 primary responsibilities. First, to expedite the implementation of the Bipartisan Safer Communities Act and the executive actions already announced. And I mean it. We're going to fully implement it. Second, coordinate more support for survivors, families, and communities affected by gun violence, including mental health care, financial assistance, the same way FEMA responds to natural disasters. That's right. Same way. We help folks recover and rebuild and all this. Look, folks, shootings are the ultimate superstar, ripping through communities. Third, identify new executive actions we can take within our legal authority to reduce gun violence. And fourth, expand our coalition of partners in states and cities across America, because we do have partners to get more. We need more state and local help to get these laws passed locally as well. And to strengthen our laws and give us more hope. Folks, to be clear, none of these steps alone is going to solve the entirety of the gun violence epidemic. None of them. But together, they will save lives. And it's going to help. It'll help rally the nation to a sense of urgency and seriousness of purpose. Today, guns, I never thought I'd even remotely say this in my whole career. Guns are the #1 killer of children in America. Guns are the #1 killer of children in America, the United States of America. More than car accidents, more than cancer, more than other diseases. In 2023 so far, our country has experienced more than 500 mass shootings, well over 30,000 deaths due to gun violence. This is totally unacceptable. It's not who we are. And we have to act, we have to act now. Let me be very clear. If members of the Congress refuse to act, then we'll need to elect new members of Congress. Democrat or Republican. Look, folks, there comes a point where our voices are so loud, our determination so clear, that our effort can no longer be stopped. We're reaching that point. We've reached that point today, in my view, where the safety of our kids from gun violence is on the ballot. At the end of the day, whether the Democrats or Republicans, we all want our families to be safe. We all want to go to school, houses of worship, grocery stores, gyms, malls, movies, without constant anxiety. We all want our kids to have the freedom to learn how to read and write in school instead of ducking cover, for God's sake. And it matters. So let me close with this. Earlier this summer, I was in Connecticut at a summit on gun safety hosted by Senator Murphy. 4 students impacted by gun violence who are here with us today summoned extraordinary courage and stood and shared their stories on stage. 4 of them. They each came from different backgrounds, different parts of the country, different shootings. But they shared a common singular message. And one of them summed up in just a few words, and I quote, "The deadly and traumatic price for inaction." That's what he talked about, the deadly and traumatic price for inaction. They made it clear what all of you know too well. That price can no longer be the lives of our children and the people of our country. They spoke for an entire generation of Americans who will not be ignored, will not be shunned, and will not be silenced. I know progress is hard. I've been at this a long time, and we've done it before. We can do it again. As we're here, I'm here to tell you, to you and Vice President Harris hears you as well. You're right. You're right. We're by your side. And we're never going to give up. You can give up dealing with this problem. We're never going to forget your loved ones. We're never going to get there unless we remember. You know, I know we'll do this because I know you. Heroes. Heroes proving that even with heavy hearts, we have unbreakable spirits. In memory of your loved ones, and building a movement that endures. Above all, we'll never give up on the one thing we must never lose: hope, hope, hope. Jill and I, Kamala and Doug, our entire administration, are more determined than ever to carry forward that hope, that inspiration, that light that you continue to give us all. For the lives we have lost, or for the lives we can save, we can do this. We just have to keep going. We just have to keep the faith. We just have to remember who we are. Every time I walk out of my grandpa's house up in Strand, we yell, "For real. Joey, keep the faith." My grandmother will know, Joey, spread it. Spread it. That's what we have to do. Spread the faith. And remember, ladies and children, we're the United States of America. There is nothing beyond our capacity when we do it together. Nothing we've ever tried to solve when we've done together we haven't succeeded. God bless you all. And God protect our troops. And God protect our children. Thank you so much.
Distinguished guests, please remain in the Rose Garden as the President and the Vice President depart. Thank you.
Chair now recognizes himself for an opening statement. The fix is in. Even with the face-saving indictment last week of Hunter Biden, everyone knows the fix is in. 4.5 years. 4.5 years the Department of Justice has been investigating Mr. Biden, an investigation run by David Weiss, an investigation that limited the number of witnesses agents could interview, an investigation that prohibited agents from referring to the president as the, quote, big guy in any of the interviews they did get to do, an investigation that curtailed attempts to interview Mr. Biden by giving the transit team secret a heads up, an investigation that notified Mr. Biden's defense counsel about a pending search warrant, an investigation run by Mr. Weiss, where they told the Congress 3 different stories in 33 days. They told this committee on June 7th, David Weiss said, I have ultimate authority to determine when, where, and whether to bring charges. 23 days later, June 30th, he told this committee, actually, I can only bring charges in my U.S. Attorney's District, the District of Delaware. And then to further confuse matters, on July 10th, he told Senator Graham, I have not sought special counsel status. Rather, I've had discussions with the Department of Justice. An investigation run by Mr. Weiss that negotiated a plea deal that the federal district court declined to accept. A plea deal so ridiculous, the judge asked this question, quote, is there any precedence for agreeing not to prosecute crimes that have nothing to do with the charges being diverted? The response from the DOJ lawyer, I'm not aware of any, Your Honor. A plea deal so ridiculous that the judge also asked, have you ever seen a diversion agreement where the agreement not to prosecute was so broad that it encompasses crimes in a different case? The response from the DOJ lawyer, no, Your Honor, we haven't. An investigation run by Mr. Weiss that not only had a sweetheart deal rejected, but according to the New York Times, there was an even sweeter deal, an earlier deal, a deal in which Mr. Biden would not have to plead guilty to anything. 4.5 years and all that, and now we get a special counsel. Now we get a special counsel, and who does the Attorney General pick? David Weiss, the guy who let all that happen. He could have selected anyone. He could have picked anyone inside government, outside government. He could have picked former attorney generals, former special counsels, but he picks the one guy he knows will protect Joe Biden. He picks David Weiss. And here's what the AG said in his August 11th announcement of David Weiss as the special counsel. Quote, I am confident that Mr. Weiss will carry out his responsibility in an even-handed and urgent manner. Urgent manner, every witness we've talked to, the 2 FBI whistleblowers that came forward, Mr. Shapley, Mr. Ziegler, the 2 FBI agents on the case, Mr. Sobocinski, Ms. Hawley, they've all said this thing was anything but urgent. The FBI said they were frustrated at the pace. Ms. Hawley said she was frustrated at the pace. And of course, the IRS agents, they said the investigation was slow-walked. And even-handed, they limited the number of witnesses that could be interviewed. They tipped off the defense counsel about a subpoena. The judge says the plea deal was a joke. And all that's just half the story. There's one investigation protecting President Biden. There's another one attacking President Trump. Justice Department's got both sides of the equation covered. Look at the classified documents case. Spring and early summer of last year, the Department of Justice asked President Trump to turn over boxes of documents. He does just that. In the process, President Trump finds 38 additional documents. He tells the Department of Justice, the very next day the FBI comes to his home and he turns them over. Then the Department of Justice asked the president to put any boxes he brought from the White House to his home in his storage room and secure it by locking it. He does that as well. Everything they asked him to do, he did. And then what's the Justice Department do? August 8th, last year, they raid President Trump's home. And according to the FBI agent, Stephen D'Antuono, the assistant director in charge of the Washington field office, the search was a complete departure from standard protocol. When we interviewed Mr. D'Antuono, he said, first, the Miami field office didn't do the search. Instead, they sent folks from D.C. He said there was no U.S. attorney assigned to the case. Instead, it was run by D.C., in particular Jay Bratt, who's now on the special counsel team. He said the FBI didn't get President Trump's counsel's approval before they did the search. And then Mr. D'Antuono told us he had recommended that when the FBI got to Mr. Trump's home, President Trump's home, they contact his counsel, wait for him to get there and do the search together. Of course, the DOJ said no. And then who does the Attorney General name as special counsel in that case? Jack Smith, the guy who a few years ago was looking for ways to prosecute Americans, targeted by Lois Lerner and the IRS, looking to prosecute the very victims of the weaponized government, the weaponized IRS. Jack Smith, the guy who prosecuted Governor McDonald, only to have the Supreme Court overturn that prosecution in a unanimous decision. That's the guy that the Attorney General of the United States selects as special counsel. And you wonder why 4 out of 5 Americans believe there are now 2 standards of justice in our great country. Mr. Garland, I anticipate a number of questions on these 2 investigations. Later in the hearing, I expect from Republicans, you will also get questions about the many other concerns the American people have with the department. The school board's memorandum, treating Catholics, the memo that said pro-life Catholics are extremists, the Fifth Circuit decision, great decision on the Department of Justice and other agencies censoring American speech, and of course the FISA law that's up for reauthorization this year, and how that process has been abused and infringed on the rights, privacy rights of the American people. Americans believe that today in our country, there is unequal application of the law. They believe that because there is. Republicans are committed to making that change. With that, I would yield to the gentleman from New York, the ranking member, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, at the outset, let me make 2 comments. One, just about every assertion you made in your opening statement has been completely refuted by witnesses who have testified before this committee. 2, far from being favored, many commentators have noted that people accused of simple gun possession while under the influence of a drug, when that gun was not used in the commission of a crime, are rarely, if ever, prosecuted the way Hunter Biden is being prosecuted. Mr. Chairman, one of this committee's most important duties is conducting oversight of the Department of Justice. We are called upon to ensure that the DOJ uses the enormous amount of power it is granted in a fair, just manner that respects the civil and human rights of all Americans. The Attorney General of the United States oversees issues that affect the lives of each and every American. Violent crime, drug trafficking, attacks on our civil rights, threats to our national security, and environmental crimes all fall under his purview. That is why we regularly request that he or she appear before this committee to speak about the work the department is doing for the welfare of the country. This is how we ensure that the department stays accountable to the American people. But if we're up to the Republicans, Americans would hear nothing about any of these substantive issues today. They would hear nothing about the rise in domestic terrorism and what the Justice Department is doing about it. They would hear nothing about what the department is doing to stop hate crimes and prevent gun violence. They would hear nothing about how the department is disrupting efforts by Russia, China, and others to interfere in our elections. Extreme MAGA Republicans have poisoned our vital oversight work. They've ignored our legitimate oversight responsibilities and used their power to stage one political stunt after another. They have wasted countless taxpayer dollars on baseless investigations into President Biden and his family, desperate to find evidence for an absurd impeachment and desperate to distract from the mounting legal peril facing Donald Trump. They have fought tirelessly to stop efforts to fight malign foreign actors trying to influence and manipulate Americans through social media. They have unconstitutionally interfered in criminal litigation and attempted to bully state and local law enforcement officers. They have publicized the names of witnesses who did not further their political goals, leading to threats of death and physical violence against those witnesses and their families. They have cost any number of private institutions and companies millions of dollars in legal fees as they struggle to respond to ridiculous and overbroad requests for information and transcribed interviews. They have issued subpoenas for show without making meaningful attempts to get the information they seek by consent. They have levied low, baseless personal attacks on any prosecutor to bring charges against Donald Trump or January 6th rioters.
They have attempted to discredit investigators who are not hard enough on Donald Trump's political opponents. They have supported those involved in the deadly attack on our Capitol on January 6th in an attempt to overthrow a lawful election. They have justified conduct that we all know to be wildly illegal, like the theft of classified materials and incitement to violence. And through it all, rather than try to unite the country or solve the problems that affect us all, they have sought to exploit our divisions for cynical, personal political gain. That is their goal, division. They want to divide this country and make our government appear like it's broken, because that is when their broken political party thrives. So today, I implore the public to see through the sham. I have no doubt that you will hear a deluge of conspiracy theories and baseless accusations. They will quote freely from so-called whistleblowers who have been broadly discredited or contradicted. They will viciously attack federal law enforcement. They will tell you that all 91 criminal charges against Donald Trump are part of a conspiracy, despite overwhelming evidence of each of Donald Trump's crimes. And they will attack Special Counsel Weiss, who was appointed, let us not forget, by Donald Trump, for not being hard enough on Hunter Biden. Republicans will continue doing what they've done for years, discrediting anyone who does not serve their political goals at any cost. And the shame of it is that in this hearing room, like on the House floor, where we are barreling towards a government shutdown while my Republican colleagues call each other names, we could be working together to put people over politics and to solve any number of problems affecting the American people. More than 30,000 Americans have died from gun violence so far this year alone. Guns have become the leading cause of death for children aged 1 to 17, surpassing car accidents. Domestic violent extremism and white nationalism are on the rise. We are seeing active clubs and other white supremacist groups pop up around the country. Anti-Semitism is at an all-time high. Malign foreign actors like Russia, China, Iran, and North Korea are attempting to influence our elections. Political rhetoric is causing threats against law enforcement officials to skyrocket. Our immigration court system is in desperate need of reform. Our election workers receive death threats from conspiracy theory-driven extremists. Fentanyl is filling our streets and poisoning our children at historic rates. This list goes on, and we, the people in this room, are in a position to do something about it. In fact, it is our duty to do something about it, consistent with the oath we took when we were sworn in as members of Congress. We could work with the Department of Justice and Attorney General Garland to address any number of real substantive problems facing the American people. Instead, House Republicans will use their time today to talk about long discredited conspiracy theories and Hunter Biden's laptop. They will do it because they care more about Donald Trump than they do about their own constituents. I hope my colleagues will see reason and at least attempt to work with the Attorney General in good faith. Sadly, on the other side of the aisle, reason and good faith seem to be in short supply. In any event, Mr. Attorney General, I thank you for your testimony and thank you in advance for your patience. I yield back.
Gentleman yields back without objection. All other opening statements will be included in the record. We will now introduce today's witness. The Honorable Merrick Garland is the Attorney General of the United States. He was sworn in on March 11th, 2021. We welcome our witness. Thank him for appearing today. We will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show that the witness has answered in the affirmative. Thank you. You can be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony. You know how this is done, Mr. Garland. You've been here before. We want to again thank you for being here. You're welcome to give your opening statement.
I'm sorry, is this working? Yeah.
You got it.
Thank you. Good morning, Chairman Jordan, Ranking Member Nadler, and distinguished members of this committee. Thank you for the opportunity to appear before you on behalf of the more than 115,000 employees of the Department of Justice. Since the Justice Department was founded, it has been tasked with confronting some of the most challenging issues before the country. Today, we are handling matters of significant public interest that carry great consequences for our democracy. A lot has been said about the Justice Department, about who we are and what we are doing, about what our job is and what it is not, and about why we do this work. I want to provide some clarity. First, who we are. The Justice Department is made up of more than 115,000 men and women who work in every state and communities across the country and around the globe. They are FBI, DEA, ATF agents, and United States Marshals who risk their lives to serve their communities. They are prosecutors and staff who work tirelessly to enforce our laws. The overwhelming majority are career public servants, meaning that they were not appointed by the president of any party. Second, I want to provide clarity about what the job of the Justice Department is and about what it is not. Our job is to help keep our country safe. That includes working closely with local police departments and communities across the country to combat violent crime. In fact, today, we are announcing the results of a recent U.S. Marshals operation conducted with state and local law enforcement. That operation targeted violent fugitives and resulted in 4,400 arrests across 20 cities in just 3 months. Our work also includes combating the drug cartels that are poisoning Americans. Last Friday, we extradited Ovidio Guzman Lopez, a leader of the Sinaloa cartel, from Mexico to the United States. He is a son of El Chapo and one of more than a dozen cartel members we have indicted and extradited to the United States. Our job includes seeking justice for the survivors of child exploitation, human smuggling, and sex trafficking. And it includes protecting democratic institutions like this one by holding accountable all those criminally responsible for the January 6th attack on the Capitol. Our job is also to protect civil rights. That includes protecting our freedoms as Americans to worship and think as we please, and to peacefully express our opinions, our beliefs, and our ideas. It includes protecting the right of every eligible citizen to vote and to have that vote counted. It includes combating discrimination, defending reproductive rights under law, and deterring and prosecuting attacks such as hate crimes. And our job is to uphold the rule of law. That means we apply the same laws to everyone. There is not one set of laws for the powerful and another for the powerless, one for the rich and another for the poor, one for Democrats and another for Republicans, or different rules depending upon one's race or ethnicity or religion. Our job is to pursue justice without fear or favor. Our job is not to do what is politically convenient. Our job is not to take orders from the president, from Congress, or from anyone else about who or what to criminally investigate. As the president himself has said, and I reaffirm today, I am not the president's lawyer. I will add, I am not Congress's prosecutor. The Justice Department works for the American people. Our job is to follow the facts and the law, and that is what we do. All of us recognize that with this work comes public scrutiny, criticism, and legitimate oversight. These are appropriate and important given the matters and the gravity of the matters that are before the department. But singling out individual career public servants who are just doing their jobs is dangerous, particularly at a time of increased threats to the safety of public servants and their families. We will not be intimidated. We will do our jobs free from outside influence, and we will not back down from defending our democracy. Third, I want to explain why we approach our job in this way. The Justice Department was founded in the wake of the Civil War and in the midst of Reconstruction with the first principal task of bringing to justice white supremacists and others who terrorize Black Americans to prevent them from exercising their civil rights. The Justice Department's job then and now is to fulfill the promise that it is at the foundation of our democracy, that the law will treat each of us alike. That promise is also why I am here. My family fled religious persecution in Eastern Europe at the start of the 20th century. My grandmother, who was one of 5 children, born in what is now Belarus, made it to the United States, as did 2 of her siblings. The other 2 did not. Those 2 were killed in the Holocaust. And there is little doubt that but for America, the same thing would have happened to my grandmother. But this country took her in, and under the protection of our laws, she was able to live without fear of persecution. That protection is what distinguishes this country from so many others. The protection of law, the rule of law, is the foundation of our system of government. Repaying this country for the debt my family owes, for our very lives, has been the focus of my entire professional career. That is why I served in the Justice Department under 5 different attorneys general under both Democratic and Republican administrations. That is why I spent more than 25 years ensuring the rule of law as a judge. And that is why I left a lifetime appointment as a judge and came back to the Justice Department 2.5 years ago. And that is why I'm here today. I look forward to your questions.
Thank you, Mr. Attorney General. And you were right. America is the greatest country ever. And we on this side, I know, are very concerned about the equal application of the law that you talked about in your opening statement. With that, we will move to 5-minute questions, and we will start with the gentleman from Louisiana, Mr. Johnson.
Thank you. Mr. Weiss, the rule of law does distinguish our country, but you have not upheld that. You have allowed the rule of law to erode. And that's why 65% of the people in this country have no faith in the Department of Justice under your leadership. They don't trust it. They don't trust you. The reason is because they're witnessing every day a politicized Justice Department in a 2-tiered system of justice. For example, they see the DOJ, of course, aggressively prosecuting President Biden's chief political rival, Mr. Trump, while at the same time, they see slow walking and special treatment given to the president's son. That's just a fact that everybody can see with their own 2 eyes. I want to focus on that investigation of the Biden family. We have many important questions for you today about that. Let me just get right to the chase. Has anyone from the White House provided direction at any time to you personally or to any senior officials at the DOJ regarding how the Hunter Biden investigation was to be carried out?
No.
Have you had personal contact with anyone at FBI headquarters about the Hunter Biden investigation?
I don't recollect the answer to that question, but the FBI works for the Justice Department. It's.
I'm sorry. You don't recollect whether you've talked with anybody at FBI headquarters about an investigation of the president's son?
I don't believe that I did. I promised the Senate when I came before it for confirmation that I would leave Mr. Weiss in place and that I would not interfere with his investigation.
Okay,
I have kept that promise.
All right. Have you had personal contact with anybody at the Baltimore field office on the Hunter Biden matter?
No.
On July 10th, 2023, U.S. Attorney David Weiss told Senator Lindsey Graham, quote, "I had discussions with departmental officials regarding potential appointment under 28 U.S.C. Section 515, which would have allowed me to file charges in a district outside my own without the partnership of the local U.S. attorney," end quote. With whom did Mr. Weiss have those discussions?
I'm not going to get into the internal deliberations of the department.
But you must, sir. This is important for us. We have oversight responsibility over your department, and we need these answers.
As appropriate and necessary for Mr. Weiss to have conversations with the department. I made clear that if he wanted to bring a case in any jurisdiction, he would be able to do that. The way you do that is to get an order signed by the Attorney General called a 515 order. I promised he would be able to do that, and he in his letters made clear he understood he would be able to do that.
Okay. Can you tell us about any briefings or discussions that you personally have had with Mr. Weiss regarding any and all federal investigations of Hunter Biden?
I'm going to say again, I promised the Senate that I would not interfere with Mr. Weiss.
So you have not, I'm just, under oath today, your testimony is you have not had any discussions with Mr. Weiss about this matter?
Under oath, my testimony today is that I promised the Senate I would not intrude in his investigation. I do not intend to discuss the internal Justice Department deliberations, whether or not I had them.
Oh, okay. So your testimony today is you're not going to tell us whether you've had discussions with Mr. Weiss.
My testimony today is I told the committee that I would not interfere. I made clear that Mr. Weiss would have the authority to bring cases that he thought were appropriate.
Okay.
Mr. Weiss's
All right.
letter.
Okay, let me stop you.
makes
For a second
clear-
time, sir, are you aware that FBI officials have come before this committee and they have stated that there was a cumbersome bureaucratic process that Mr. Weiss had to go through to bring charges in another judicial district? You know that?
I'm not aware, but that's not true. There's nothing cumbersome about the process.
So those
All I
whistleblowers
need
are
to-
lying to us under oath? Those whistleblowers are lying?
I
Is
can
that your
say
testimony?
that. Their description of the process cumbersome is an opinion. It's not a fact question. All I have to do is
Okay,
sign a
all right,
section.
let me get to the fact. Mr. Weiss has been the lead prosecutor on the Hunter Biden case since 2018, correct?
I'm sorry?
Mr. Weiss has been the lead prosecutor on the Hunter Biden case since 2018. Now, here's the question.
He's been the lead prosecutor since he was appointed by President Trump.
Okay,
And
why,
assigned-
let me ask you, why has the Justice Department dragged this investigation out for so long? Does it really take years to determine if Hunter Biden lied on a federal form related to purchasing a firearm?
Mr. Weiss was a longtime career prosecutor. President Trump appointed him as.
You're not answering the question. Is that standard procedure? Should it take that long to make such a simple determination?
I'm answering the question.
Mhm.
Give me an opportunity to do so.
Okay.
He was charged with that investigation under the previous administration. He's continued. He knows how to conduct investigations, and I have not intruded or attempted to evaluate that because that was the promise I made to the Senate.
The whistleblowers gave us testimony about serious misconduct at the Justice Department in regards to the preferential treatment afforded Hunter Biden. Has your office requested an investigation into that?
There are well-known processes for how whistleblowers make their claims. I am a strong proponent of whistleblowers and a strong defender. We have an Inspector General's office. We have an Office of Professional Responsibility. That is the way in which complaints from whistleblowers should be and are appropriately handled.
I'm out of time. I yield back.
Gentleman yields back. The chair recognizes the ranking member, Mr. Nadler. Okay, Dan.
Thank you. Mr. Attorney General, thank you for being here today. It's no secret that some of my colleagues across the aisle have threatened to shut down the government unless and until the FBI and the Department of Justice are defunded. One Trump-light presidential candidate has said that we should abolish the FBI altogether. Mr. Attorney General, what would be the impact on America of defunding the FBI?
Defunding the FBI would leave the United States naked to the malign influence of the Chinese Communist Party, to the attacks by Iranians on American citizens and attempts to assassinate former officials, to the Russian aggression, to North Korean cyber attacks, to violent crime in the United States, which the FBI helps to fight against, to all kinds of espionage, to domestic violent extremists who have attacked our churches, our synagogues, our mosques, and who have killed individuals out of racial hatred. I cannot imagine the consequences of defunding the FBI, but they would be catastrophic.
Thank you. I want to turn to Mr. Weiss's investigation and the authority he's been granted to conduct that investigation without interference in whatever way he deems necessary. You testified to the Senate Judiciary Committee on March 1st of this year that David Weiss had, quote, full authority over any investigation concerning Hunter Biden. Was that a true statement at the time?
Yes, Mr. Weiss has full authority to conduct his investigation however he wishes, and Mr. Weiss has confirmed that in letters to this committee.
Thank you. This authority included ensuring that Weiss would be able to bring charges in jurisdiction outside of Delaware if necessary. Is that correct?
I assured Mr. Weiss publicly that he would have the authority to bring a case outside of Delaware if he thought that was appropriate.
Does that remain true today?
Yes, that is true today.
Has it ever been the case over the course of this investigation that Mr. Weiss would not have been able to bring charges outside of Delaware if warranted?
As a matter of my authority, I promised he would be able to do that. I think as is apparent in the letters exchanged with the committee and in my last previous testimony, in order for a United States attorney or a special counsel or anyone else to bring a case outside of his jurisdiction, it requires me to sign a paper called Section 515. That's the statute which permits bringing cases outside of the jurisdiction. I promised that I would do whatever was required to enable Mr. Weiss to bring a case outside his jurisdiction if that's what he thought was appropriate.
And I assume it was your understanding that Mr. Weiss was fully aware that he could bring charges outside of Delaware if necessary when you testified on March 1st.
Mr. Weiss has said so in the letters he sent to this committee.
Thank you. Did he ever say or do anything that might make him unsure of where he could bring charges?
Mr. Weiss's own letters reflect that he had never asked me to be special counsel and that he understood the process for asking for a signature on a Section 515 form.
There have been accusations that the handling of the Hunter Biden matter is an example of a two-tiered system of justice. What's your response to that allegation?
The Justice Department treats everyone alike, regardless of party, regardless of ethnicity, regardless of wealth. Everyone is treated alike. I understand that people may not understand why particular investigations are conducted in particular ways until all the facts come out. That's what we have a court for. And all of the explanations will come out with respect to Mr. Weiss, for example, at the end of his period as special counsel. One of the requirements is that he file a report, which I have promised to make public to the extent that's lawful and consistent with department policy. He will explain his decisions to prosecute and not to prosecute.
Thank you. What are the impacts of members of Congress making such accusations against the DOJ? Do baseless accusations from government officials make it more difficult for investigators to do their job and effectively investigate the subject?
Look, members of the Justice Department are strong and tough and able to understand that their job is to do the right thing regardless of any pressures from any quarter. What is dangerous, and I'm not talking about the committee, but what is dangerous is when anyone singles out a career prosecutor or a career FBI agent, and we know as a matter of fact that that kind of singling out has led to threats. This is a concern across the board. It is not a concern about anyone in particular.
I think you would have been justified in referring to the committee. My time has expired. I yield back.
Gentleman yields back. Chair recognizes the gentleman from North Carolina.
If you've got the drive to get the work done, come get the tools at a value that can't be beat at Harbor Freight.
Mr. Attorney General, you're the only person who could ensure that Mr. Weiss had all the necessary authority, aren't you?
I'm the only person who can sign an agreement with respect to special counsel. The authority to do Section 515 can be signed by other people in the department.
You're aware, ultimately, though, the authority is yours.
Yes.
You made the point that you don't take orders from the president about such things. You decide ultimately what the Justice Department will do.
I announced at the beginning, I promised that he would be able to bring whatever cases he wants, and I have followed through on that promise. I'm permitted to make that kind of promise, and I have made it.
Did you undertake to inform yourself, to interact with him sufficient to ensure that he knew he possessed that authority, or that you would see to it that he had all necessary
I
authority?
don't think there's any doubt that he knew. He has written 3 letters to this committee indicating that he understood he had that authority.
You're also aware, though, aren't you, sir, that a senior IRS investigator, whistleblower, came forward and has testified publicly that Mr. Weiss stated that he did not have such authority. He was not the decider. Are you aware of that?
I'm aware of the testimony. I was not present at any point during that statement. And Mr. Weiss, who was present, has indicated that he had the authority and he knew that he had it.
Subsequent to those developments, though, you decided to make Mr. Weiss special counsel, which you had not done before.
Mr. Weiss made clear he did not ask me to be special counsel. until last month, and last month I made him special counsel.
Did you have some lack of information that you should have had that would have caused you to act earlier to make him special counsel?
Mr. Weiss did not ask to be special counsel before.
I understand he didn't ask. You've said that, sir. Did you take the necessary steps to inform yourself what authority he understood he had or what obstacles he was encountering?
Mr. Weiss had, as I said from the beginning, at the very beginning, that he had authority over all matters that pertain to Hunter Biden.
Have you learned that he was in fact deterred by decisions of the United States attorneys in the District of Columbia and the Northern District of California from proceeding as he thought best?
With respect, Congressman, Mr. Weiss has not said that he was deterred. He said that he followed the normal processes of the department, and that he was never denied the ability to bring a case in another jurisdiction.
Well, what changed then, Mr. Attorney General? What made you decide that it was sufficient to leave him in the situation he was until you decided to make him special counsel?
Mr. Weiss asked for that authority, given the extraordinary circumstances of this matter, and given my promise that I would give him any resources he requested, I made him special counsel.
So until that time, was it just a matter of his predilection, or did you undertake to investigate and discern what he was doing with his authority and whether he faced any obstacles?
I did not endeavor to investigate because I had promised that I would not interfere with this investigation. The way to not interfere is to not investigate an investigation.
Once he requested to be named special counsel, having not done so over months and months of your tenure, did you ask him what had changed that made him now need to be a special counsel?
Mr. Weiss asked to be made special counsel. I had promised that I would give him all the resources he needed, and I made him special counsel.
When did the Justice Department permit statutes of limitations to expire on some of the prospective charges against Hunter Biden for tax violations?
I don't know anything about the statute of limitations here. The investigation was in the hands of Mr. Weiss to make the determinations that he thought were appropriate.
Are you unaware that statutes of limitations have in fact been allowed to expire after there having been tolling agreements in place?
I'm going to say again, determination of where to bring cases and which kinds of cases to bring was left to Mr. Weiss.
Yes, sir. I understand that you've said that. That's part of the problem. The question is, are you aware that statutes of limitations have been allowed to expire while the matter was under investigation?
The investigators were fully familiar with all the relevant law.
I'm not asking for the excuses. I'm asking whether you're aware of that fact, sir.
I'm going to say again. I'm going to say again and again if necessary. I did not interfere with, did not investigate, did not
See,
make
those are
determinations.
statements in response to other questions. Everybody in the country now knows who's paying attention to this, that the Justice Department permitted statutes of limitations to expire. Every lawyer who's ever practiced understands the implications of allowing statutes of limitations to expire. Do you not even know as you sit here whether that occurred or not?
Prosecutors make appropriate determinations on their own. In this case, I left it to Mr. Weiss whether to bring charges or not. That would include whether to let statute of limitations expire or not, whether there was sufficient evidence to bring a case that was subject to the statute of limitations or not, whether there were better cases to bring or not.
Time, gentleman, has expired. The chair now recognizes the gentlelady from California.
Thank you, Mr. Chairman, and thank you, Attorney General, for being here with us this morning. You know, as much as we see dirt being thrown in the air, there's a lot of misinformation that I think is intended to confuse people. I would like to ask unanimous consent to put into the record 3 letters from Mr. Weiss that he sent to Congress on June 7th, June 30th, and July 10th.
Without objection.
He said over and over again that he has full authority over this case, including the ability to seek special counsel or special attorney status if needed. You know, trying to imply otherwise is just simply false. Mr. Weiss was appointed by then President Trump. Your decision was to leave the Trump-appointed attorney completely in charge of this, hands off from you. He makes all the calls without interference from the Attorney General. Is that correct?
That is correct.
And so the idea that you would interfere is completely wrong. And I'd also like to ask, you talked about your independence from the president, but also your independence from the Congress. Have you ever come across historically an instance where the Congress of the United States tried to or successfully interfered with a prosecution initiated by the Department of Justice based on the facts and the law?
How's the scented angel soft coming?
Angel, we've got it. The smellinator is at the scent inside the tube.
Every tube also adds a hint of freshness? So much simpler.
By golly, it is simpler.
Angel soft. Soft and strong. Simple.
I want to be gentle about the word interfere, but it is just as a historical example in the case of Iran-Contra. The consequences of actions by the Congress were that the special counsel's investigation of Iran, of Mr. North, were dismissed.
Correct. Before I go into another question I have, I just would like unanimous consent to put into the record the annual statistical transparency report dated April of 2023. It indicates that the deduplicated counting method for FBI queries of U.S. persons under the Section 702 database numbered over 119,000. I would just like to note, and we will work with you, this committee on a bipartisan basis is very concerned about querying of the 702 database for U.S. persons without a warrant. We're not suggesting that the law does not permit that, but we are going to visit this issue because it is my view that querying the 702 database that has been collected without due process, because it relates to foreign individuals, is completely wrong in terms of the privacy rights of Americans. And I'm hoping that we can work successfully with you as we craft requirements for a warrant to do that querying. I'd like to ask, as we know, and has been mentioned by the ranking member, the proposal is basically to defund the police by the Republicans, to defund the FBI. I am concerned that if we defund the police, as the majority has suggested, that really doesn't have an impact on the statute of limitations. So if we were to defund the Department of Justice, defund the FBI and the police, as has been suggested, what would happen with the statute of limitations for cases that you were pursuing if you were not able to actually do that? Would they be suspended anyway, or would the criminals get off scot-free?
Well, I know in my experience as a judge, if I was asked a legal question and I don't know the answer, I would go back to the office and study it, and I'll have to do that in this case. I don't have the answer.
Well, I think I do, because there's nothing in the statute that allows for the statute of limitations to be suspended because the government has been shut down or because the police have been defunded through the budget process. And I just think we ought to take the implications of a shutdown very seriously in terms of allowing criminals to get off. And I see that my time has expired, Mr. Chairman, and I yield back.
General yields back. Chair does not recognize himself. Quote, Mr. Weiss has full authority to bring cases in other jurisdictions if he feels it's necessary. That was your response, Attorney General, to Senator Grassley's question on March 1st, 2023. You just referenced it when Mr. Bishop was questioning you. Only problem is he'd already been turned down by the U.S. Attorney in the District of Columbia, Mr. Graves. So he didn't have full authority, did he?
I had an extended conversation with Senator Grassley at the time. We briefly touched on the Section 515 question and how that process went. I've
My
never
point's real
been
simple. My
suggested.
point's real simple, Mr. Garland. You said he had complete authority, but he'd already been turned down. He
can't
wanted to
be-
bring an action in the District of Columbia, and the U.S. attorney there said, no, you can't. And then you go tell the United States Senate under oath that he has complete authority.
I'm going to say again that no one had the authority to turn him down. They could refuse to partner with him. They could
You
not.
can use whatever language. Refuse to partner is turning down.
Well, it's not the same under a well-known Justice Department practice.
Here's why the statute of limitations question is important, and Mr. Bishop was getting at just a few minutes ago. Here's why it's important. You let the statute of limitations lapse for 2014, 2015. Those were the years with the felony tax charges where Hunter Biden was getting income from Burisma. Here are 4 facts that I think are so important. Hunter Biden was put on the board of Burisma, made a lot of money, got paid a lot of money over those years, a couple $1 million. He wasn't qualified. Fact number 2, he wasn't qualified to be on the board of Burisma. Not my words, his words. He said he got on the board because of his last name. The brand, as Devin Archer said when he was under oath and we deposed him. Fact number 3, Burisma executives told Hunter Biden, we're under pressure, we need help. Fact number 4, Joe Biden goes to Ukraine, leverages our tax money, American people's tax money, to get the prosecutor fired who was applying the pressure. Interestingly enough, that fact is entirely consistent with what the confidential human source told the FBI, and they recorded in the 1023 form, the same form Mr. Ray didn't want to let this committee and the Congress see. That all happened. That all happened. And what I'm wondering is why you guys let the statute of limitations lapse for those tax years that dealt with Burisma income.
There's one more fact that's important, and that is that this investigation was being conducted by Mr. Weiss, an appointee of President Trump. You will, at the appropriate time, have the opportunity to ask Mr. Weiss that question, and he will no doubt address it in the public report that will be transmitted to the Congress. I don't know the answer to those questions.
Did they forget? Did the lawyers just like let it, did they just like, oh, darn, we let it, were they careless?
I expect that won't be what he says, but because I
You
promised.
know that's not the case, because as Mr. Bishop pointed out, they had a tolling agreement. They talked to Hunter Biden's defense counsel and say, let's extend the statute of limitations. And then at some point, they made an intentional decision to say, we're going to let the statute of limitations lapse. And I want to know who decided that and why they did it.
Mr. Weiss was a supervisor of the investigation at that time and at all times. He made the appropriate decisions, and you'll be able to ask him that question, and he will.
You know why they did it? Everyone knows why they did it. May not say it, but everyone knows why they did it. They didn't. Burisma, those tax years, that dealt with that involved the president. It's one thing to have a gun charge in Delaware. That doesn't involve the president of the United States. But Burisma, oh my, that goes right to the White House. We can't have that. And we can slow walk this thing along. We can even extend the statute of limitations, and then we can intentionally let it lapse. And we know this investigation was slow. Here's what everyone said. Shapley said, DOJ slow walked the investigation. Ziegler, slow walking in the approvals of everything. This happened at the Delaware's attorney's office and DOJ tax level. Mr. Sobocinski, the FBI agent, said, I would have liked to see things move faster. Ms. Holly said the same. Every witness we've talked to said this thing was slow walked, and we know why. They slow walked it long enough to let the statute of limitations run so they wouldn't have to get into Burisma. Tell me where I'm wrong.
Will the gentleman yield?
No, I'm asking Mr. Garland the question.
I think I've tried to make clear that I don't know the specifics of the investigation. Much of what you are describing occurred during the Trump administration, during a Justice Department appointed by President Trump.
No, it didn't. This is 4.5 years, this investigation. We're talking about the last few years. Your statement was just this year, March 1st, to Senator Grassley.
No, I'm sorry. I was trying to respond to your descriptions of what the IRS agent said about certain
Statute of
things.
limitations is 6 years. That lapsed here in the Biden administration.
On the statute of limitations, we'll say again that the explanation for why the statute of limitation was lapsed, if it was, has to come from Mr. Weiss.
My time is this, but let me ask one last question real quick here. Who decided that David Weiss would stay on as U.S. attorney?
This had occurred before I came. Mr. Weiss had been kept on. I promised the.
No, I didn't say, you can walk all through that. I said, who decided?
Before Shopify, were you wondering, where are my sales at? But now you're selling with Shopify. You're easily selling online, in person, and beyond. Discover how millions of entrepreneurs use Shopify to ignite their selling. Sign up for a $1 per month trial period at shopify.com/YouTube audio.
The White House decided, right?
Weiss,
They serve at the pleasure of the president, right?
Mr. Weiss was
Joe Biden decided to keep David Weiss as U.S. attorney. You weren't sworn in until March. He was told he was going to stay on in February.
Expired.
Pretty fundamental question. Who decided David Weiss was going to stay as U.S. attorney in Delaware?
Mr. Weiss,
your time has expired.
Chairman, your time has expired.
I'm waiting for an answer now, and I'll.
Well, you asked the question after your time had expired already. Point of order.
Gentleman can respond, then I'll go to Ms. Jackson Lee.
Mr. Weiss was the special U.S. attorney from the District of Delaware when I came on. He had been appointed by President Trump. I promised that he would be permitted to stay on for this investigation, and that is what happened.
Gentleman from
Mr. Chairman,
Texas,
Mr. Chairman.
Gentleman from New York's recognized.
Mr. Chairman, I believe you misquoted from the transcript of the Senate hearing. I therefore ask unanimous consent to enter into the record the entire transcript of the Senate hearing.
Without objection, but I didn't misquote what Mr. Garland said. Ms. Jackson Lee from Texas, recognized for 5 minutes.
Thank you, Mr. Chairman. None of the Republicans' goals today include solving Americans' problems of which they are concerned of. There are many reasons, Mr. Attorney General, that prosecutors decline to bring charges. One of those reasons is that they don't have any evidence for a conviction. That is the justice way. That is just in America. So let me raise these questions and concerns with you today. As we all know, Republicans have repeatedly alleged that the DOJ and FBI are conspiring to shield the Biden family from public criticism and giving Hunter Biden special treatment in its investigations. They have demonized law enforcement officials working with this case at every turn, which has directly led to increased threats against FBI officials, law enforcement, of which they pretend to support. I want to place into the record 2 excerpts from recent transcribed interviews, and I would ask that copies be made available to you. The first is from a June interview with Jennifer Moore, FBI's former Executive Assistant Director for Human Resources. She told this committee that FBI had received so many threats that it had to stand up an entire 10-person unit just to deal with them. She said it is unprecedented. It's a number we have never had before. More testimony pages 202 to 203. The second excerpt is from an interview earlier this month with Thomas Sobocinski, the special agent in charge of FBI's Baltimore field office. Here's what he said. I joined the FBI 25 years ago. I joined for a reason, to protect the American people, uphold the Constitution. I've been to war. My family's been in bad places. My kids have been evacuated from war zones or quasi-war zones. I've been in some bad things. I've accepted that. I'm solely focused on 2 things, and they're not mutually exclusive. The first is, like every investigation, I want to get to a resolution in a fair, apolitical way. The second thing, it's becoming more important and more relevant, is keeping my folks safe. And that part, I've never expected to have to be able to be concerned about keeping families safe. So that, for me, this is becoming more and more of a job that I have to do and take away from what I was assigned or signed up to do, which was to investigate and do these things. So when you talk about potential frustrations with communication, I am personally frustrated with anything that places my employees and their families in enhanced danger. Our children, their children did not sign up for this. Mr. Attorney General, do you agree that politically charged rhetoric claiming that law enforcement agents, and I have many questions if you could be brief, are corrupt and contribute to this onslaught of threats against public servants?
Okay, as I said in my opening statement, we have had an astounding number of threats against public servants over the last several years. I think that when career public servants in the Justice Department and in election workers and airline crews, when they are singled out, this can lead to threats of violence and actual violence.
Thank
We
you.
have the actual example of an attack on an FBI office by somebody who was incensed by political rhetoric. This does happen. We must not allow that to happen in this country.
Does the rhetoric regarding the Biden case have any basis in reality?
I'm sorry, I didn't hear the first part.
Does the rhetoric regarding the Biden case have any basis in reality?
No, it does not.
How does this impact FBI and DOJ employees' ability to do their work? I think you mentioned specifically FBI and DOJ employees.
As I've already said, the agents of the FBI and the prosecutors understand that criticism comes with their job, and they will continue to do their jobs without fear or favor. But the idea of threatening their safety or that of their families is just abhorrent.
Thank you. And I assume that provisions have had to be in place to protect these agents and their families.
I'm sorry, I didn't hear the first part.
I assume that provisions or protections have had to be in place to protect these agents and their families.
Yes, that's correct.
Let me move on. Thank you very much, General. Let me move on to the fentanyl crisis, and I want to introduce HR 4272. But let me just put on the record so that you can probably summarize, and I ask for the indulgence of my chair, but in any event, that the FBI, the DOJ are focused, needlepoint focused, if you will, on the crisis of fentanyl. I want to just raise that for you, and then I just want to follow up with one or two other questions, if you would be able to comment on these collectively. I am dealing with the crisis of human trafficking and the prioritizing of America's children. They are under siege. And the level of child sexual abuse materials generating into human trafficking, and I want to put HR 30 on the record, indicates from ICAC that there are 99,000 IP cases where they're enticing children, and maybe only 1% of them being investigated. I'd like your comment on that. And finally, in the approach of of Yom Kippur, to emphasize the work that is hopefully still being doing with anti-Semitism, attacks on immigrants and African Americans and Latinos. If you would answer those questions, fentanyl, the human trafficking, and then domestic terrorism.
These are all horrendous problems propagated by people who are truly evil. We are fighting the fentanyl scourge in every possible way, starting with the precursors in China, to the labs in Mexico, to the cartels that are bringing the drugs into the United States, to their networks in the United States, to the streets of America. And we will continue to do that with every resource that Congress gives us. Human smuggling and sex trafficking are obviously abhorrent. The Justice Department has task forces on both of these subjects and have brought many, many cases on these subjects. The idea of putting sexually explicit material about children on the web is another area that we are continuing to investigate and to prosecute and to ask the social media to take down from their sites.
Gentlelady's time has expired. The gentleman floor is recognized for 5 minutes.
I guess I'm just wondering, Mr. Attorney General, has anyone at the department told President Biden to knock it off?
That feeling when you discover an epically whitening charcoal toothpaste? Holy she means holy spit. Hello.
With Hunter. I mean, you guys are charging Hunter Biden on some crimes, investigating him on others. You've got the president bringing Hunter Biden around to state dinners. Has anyone told him to knock it off?
Our job in the Justice Department is to pursue our cases without reference to what's happening in the outside world.
Just yes or no. Have you done that?
That is what we do.
So it's a no?
No one that I know of has spoken to the White House about the Hunter Biden case.
I'm wondering
Of
then,
course not.
okay, I got it. So Hunter Biden is selling art to pay for his $15,000 a month rent in Malibu. How can you guarantee that the people buying that art aren't doing so to gain favor with the president?
The job of the Justice Department is to investigate criminal allegations. You have
Are you
information.
investigating this? I mean, someone who bought Hunter Biden's art ended up with a prestigious appointment to a federal position. Doesn't it look weird that he's become this immediate success in the art world as his dad is president of the United States? Isn't that odd?
I'm not going to comment about any specific.
Not going to comment, not going to investigate. So
right.
Hunter Biden associate Devin Archer told us that Hunter sold the appearance of access to then Vice President Biden. Are you confident he has stopped doing that?
I'm sorry, I didn't understand the question.
Hunter Biden associate Devin Archer told us that Hunter sold the appearance of access to then Vice President Biden. Are you confident he has stopped?
I'm going to say again that all these matters are within the purview of Mr. Weiss. I have not interfered with them, and I
Yeah, but
do
if you were
not,
confident that he had stopped, you could.
and I do
you could
not
probably
intend
tell
to
us
interfere with
he
it.
had. So it was a lot of Chinese money that was working its way through these shell companies into the accounts of the Biden family. So the China initiative was set up during the Trump administration at the Department of Justice to go after the malign influence of the Chinese Communist Party. And the Biden Justice Department dissolved the China initiative. So I guess I'm wondering, does the department have any documents that would detail the basis for why you got rid of the China initiative that President Trump had set up?
The Assistant Attorney General for the National Security Division gave a long speech which explained that. He has testified before Congress several times. We'd be happy to provide you with.
What's the basis? Just tell us all now. Why was the China initiative dissolved?
What the Assistant Attorney General said was that we face attacks from 4 nation states: North Korea, China, Russia, and Iran. And that we need to focus our attention on the broad range of these attacks. Sometimes we don't know.
Wait a second. Are you saying that North Korea has the same malign influence risk to the United States as the Chinese Communist Party? Are you trying to represent there's some parity there? Because here's what it looks like. It looks like the Chinese gave all this money to the Bidens, and then you guys came in and got rid of the China initiative, and it was successful. Like I saw one rationale that you guys got rid of the China initiative because it was racial profiling. But one of the people you convicted was a guy named Charles Lieber, who was a Harvard professor taking $50,000 a month to do China's bidding and give them whatever research was being done. Are you aware of the millions of dollars that moved through Rob Walker's shell companies from Chinese Communist Party entities into Biden family bank accounts? Are you aware of that?
There were a lot of questions that you just asked. Let me start with the first one about North Korea. North Korea is a dangerous actor, both kinetically and with respect to cyber.
But not on par with China. I'm on the Armed Services
I'm not in the
Committee, Mr.
business
Attorney
right
General.
now.
It makes you look unserious to suggest
May
that.
I answer your question or not?
Answer the question about whether or not you know about all the millions of dollars that
So
moved
you
through
don't
Rob
want me to
Walker's
answer about North Korea?
I already know the answer, and so does everyone. They're not the same risk as China. So let's get on to serious questions and serious answers. Do you know about the money that moved through Rob Walker's shell companies, yes or no?
As I have said repeatedly, I have left these matters to Mr. Weiss. I've not
Blissfully
intruded.
ignorant.
I've not interfered.
Blissfully
I've
ignorant
not
to these
tried to
things.
find out what
It's
he
like
knows.
you're looking the other way on purpose because everybody knows this stuff's happening. And you know what? People don't pay bribes to not get something in return. Right? The China initiative resulted in the convictions of a Harvard professor, of someone at Monsanto. So we were working against the Chinese. They paid the Bidens, and now you're sitting here telling me that North Korea is the big threat. I got to get to this one thing on January 6th. So did the FBI lose count of the number of paid informants on January 6th?
Let me answer your question about China.
I want you to answer
China
this
is the
question. I only get
most-
5 minutes. You've already sort of, I think,
asked
screwed
me
the
a
pooch on
question
China.
you haven't
So
permitted-
January 6th, did you lose count of the number of federal assets? Did you lose count and order an audit?
Gentleman's time has expired.
I get an answer to the question of did they lose count?
No,
of
let
the
him
number-
answer the question.
Time has expired. The Attorney General can respond.
China is the most aggressive, most dangerous adversary that the
Attorney General, I think
United
that-
States faces, and we are doing everything within our power to rebut that, to stop that, to prevent their invasions, both kinetic, and through cyberspace. And we will continue to
If
do
someone
that.
gave that answer in your courtroom when you were a judge, you would tell them they were being
Mr. Chairman,
non-responsive and you would direct them to answer the question.
Point of order, Your Honor.
Time is,
Badgering the witness.
Point of
Time
order,
has
please.
expired.
I got it. I was.
You like Your
laughing.
Honor? You want to stick with that?
Yeah, I was getting
Okay.
laughed at to call me Your Honor.
Point of order either way.
I understand that too.
All right.
But The gentleman asked his question before his time expired. The Attorney General did not respond to the gentleman's question. I was hoping he would respond to the question about the confidential human sources on January 6th. He didn't respond to that. I'm sure we're going to get an answer to that later.
Of course,
Now-
Mr. Chairman,
now
there were
recognize
8
the
questions before that he was not given a chance to answer.
Understand,
So
but
the witness might have thought.
But the witness doesn't,
This was
Mr.
his
Chairman,
chance to
point of
answer
order.
the
The witness does not control the time.
hang on. Exactly right. Members control the time. If they want to switch their question and focus on one more question that they'd like an answer to, I want to give the witness a chance to respond to that final question that Mr. Gates asked. He didn't respond to it. Someone else is going to ask it, I'm sure. We now recognize the gentleman from Tennessee for 5 minutes.
Thank you, sir. I'll just follow up a few of the questions we were asked here. Did Devin Archer not say Joe Biden did nothing wrong?
Be clear, I only know about Mr. Archer from newspaper reports. Want to be clear that I kept my promise to not involve myself in this
Okay,
investigation.
now stated. He said Joe Biden did nothing wrong. Secondly, did you say that President Trump appointed Weiss, who then you appointed?
Yes, President Trump appointed Mr. Weiss as United States Attorney.
So that should take care of that issue. And they say the department's been weaponized. Wasn't there an investigation of Mr. Gates and you didn't prosecute him?
Justice Department does not make comments about its
Well, it
investigation.
shows you we're not weaponized. If we were weaponized, we'd have done it. That was a beautiful exchange there. And it shows we didn't do that. You are the nation's chief law enforcement officer, and I appreciate that. And law enforcement's one of our government's fundamental functions. Crime is growing too much in this country and in my city of Memphis as well. We need law enforcement to be effective, swift, and fair. I'd like to focus my questions on what actually affects the American people. Crime. How do we get smarter law enforcement requiring smart resource of allocations, not about funding or less funding, but the right funding for the right programs, and see that that happens? Memphis, as hiring has become more difficult, we've lowered our standards to get more officers. That's not the way to do it. The COPS program is helping us review the policy and procedures, and I thank you, the COPS program, for doing that. But what can Department of Justice do to help see that law enforcement is more efficient and more effective?
So the key to this is our partnership, the FBI, DEA, Marshals, ATF's partnership at every local level with local and state law enforcement, in task forces, in discussions to target the most dangerous criminals in those communities, but at the same time to engage the communities to help engender community trust in law enforcement. Everyone who's prosecuted violent crime cases, and that includes me, knows that you need the trust of the community in order to get witnesses. We in the Justice Department are helping our state and local colleagues do just that. The funding you described from the COPS office and in the Office of Justice Programs allows us to give money to state and local police organizations that are having trouble with recruitment and retention and promotion of law officers, and helps them make their departments respectful of constitutional rights, and at the same time effective in the investigation and prosecution of criminal law violations.
Thank you for those activities, those programs through COPS. You've also reinstituted patterns and practices investigations of certain police departments, and Memphis is one of them, and I thank you for doing that. Can you share with us how important those pilot programs are and how they can improve policing?
Keep it quilted means you keep it the best. Keep it quilted means comfort that feels good and does good, with 5 million trees planted. For her and for generations to come. Keep it quilted with Quilted Northern.
Yes, Congress has authorized the Justice Department to conduct pattern or practice investigations when they have a reasonable belief in that there has been a pattern of unconstitutional behavior in a police department. We are careful to select those cases where we think there is such a pattern. We make those investigations. We then work with the law enforcement agencies in the cities. Our hope is to come to a consent decree that will lead to a better, more efficient, and more constitutional police department. We have been successful in all of our cases to date in reaching consent agreements.
Thank you, sir. You were part of announced bringing of charges, federal charges against the 5 officers who killed Tyree Nichols in Memphis. And I thank you for that. We need that federal charge, and we need our department looked at. If there's a shutdown of the federal government, how will that affect the Department of Justice and affect policing in local communities?
I haven't done a complete calculation on the effects of a shutdown and the difference between which employees are indispensable under the statute and which ones not. It will certainly disrupt all of our normal programs, including our grant programs to state and local law enforcement, and to our ability to conduct our normal efforts with respect to the entire scope of our activities, including helping state and locals fight violent crime.
Thank you, sir, and Happy New Year, and I yield back the balance of my time.
Gentleman yields back. The gentleman, Mr. McClintock from California, is recognized.
Thank you, Mr. Chairman. Mr. Attorney General, looking again at the appointment of Jack Smith and David Weiss, this double standard of justice couldn't be more glaring. Jack Smith was deeply involved in the IRS scandal that targeted conservative political groups to harass. His malicious prosecution of former Governor McDonnell was unanimously overturned by the U.S. Supreme Court. Chief Justice Roberts rebuked Smith directly for attempting to criminalize political activity. You appointed him to prosecute Joe Biden's chief rival for the presidency. And then we have the appointment of David Weiss. Weiss deliberately allowed the statute of limitations to run out on any charges that could have implicated Joe Biden in influence peddling. He originally offered Hunter Biden a sweetheart deal that was ultimately upended by the court. And he's the one you appointed to pursue the charges that could implicate Joe Biden. That leads me to only 2 explanations, either corruption or incompetence. So which is it?
Those are the kind of questions that judges would rule out of order.
I'm sure you would. Which is it?
Look, I said before, and I will say again, Mr. Weiss was the Republican-appointed United States Attorney appointed by President Trump.
Do you at least see the obvious double standard applied in these 2 appointments?
Mr. Weiss was a Republican appointee. Mr. Smith is not registered to either party. His entire career was as a career prosecutor.
I'm not asking what their party registrations are. I'm asking about their records and how those records would commend them to the appointments that you made. This is a question of judgment, and it's a question of motive. What was motivating you to do this?
Mr. Smith had a nationwide reputation for integrity and for appropriate prosecution. His work can be measured by what he actually has filed. Everyone in the country can see the indictments.
How can you say that after he was so heavily implicated in the IRS scandal or the rebuke that the Supreme Court gave and many other examples? But let me go on. We've had 2 IRS whistleblowers inform Congress of attempts by senior Justice Department officials to obstruct the criminal investigation into millions of dollars of ill-gotten and undeclared income to Hunter Biden. They noted several deviations by department officials from normal process that provided preferential treatment, in this case to Hunter Biden, a direct quote, including allowing the statute of limitations to lapse, requesting IRS and FBI management level investigative communications, prohibiting investigators from referring to the big guy or dad in witness interviews, excluding the investigative team from meetings with defense counsel, and notifying defense counsel of pending search warrants. The U.S. Attorney's Office even tipped off the Bidens of an impending search of a storage unit where their records were being kept. Now that sounds an awful lot like obstruction of justice to me. Was that coming from you or from somebody else?
I'm sorry, I don't was that coming from you? I don't understand the question.
All of the actions that your employees took to obstruct the investigation of Hunter Biden and the earnings that he made and the taxes he failed to declare, their source, and ultimately who they were paid to.
I'm going to say again, with respect to the Hunter Biden investigation, that it has been and still is in the hands of Mr. Weiss, an appointee of President Trump. I don't know about all of these allegations. Some of them appear to have been from the period when the Attorney General appointed by President Trump was still the Attorney General.
Do these charges trouble you at all?
Mr. Weiss will have an opportunity to explain the decisions.
Well, you're
that
the
he
guy
made.
in charge. Does this trouble you?
I have intentionally not involved myself in the facts of the case, not because I'm trying to get out of responsibility, but because I'm trying to pursue my responsibility.
Your FBI director testified before this committee of an uptick in, quote, known or suspected terrorists coming across the southern border. And he told us that the southern border represents a massive security threat. Those were his words, a massive security threat. Do you agree?
I am perfectly happy to align myself with the director of the FBI.
Well, why is it then that we, senior administration, rescind the Trump era orders that had secured that border? I mean, we've seen an exponential increase in suspected terrorists.
Time of the gentleman has expired. The witness can respond. He chooses.
This is the answer to this question about immigration law is an extremely long answer. I would defer to the Department of Homeland Security, which is responsible for the physical security and about first contact at the border.
Well, we've tried to get answers from him. He doesn't give them to us, so we're hoping you would. I understand, Mr. Attorney General, you've requested a short break, so we'll take a short break and resume in 5 minutes.
Okay, sorry.